The committee will please come to order. We have ascertained that a quorum is present. The committee meets today pursuant to notice to consider HR 7, the Paycheck Fairness Act, HR 1065, the Pregnant Workers Fairness Act, and HR 1195, the Workplace Violence Prevention for Healthcare and Social Service Workers Act. The chair announces that any request for recorded votes will be rolled pursuant to Clause 2, Rule 11 of the Rules of the House of Representatives and Committee Rule 14B. Pursuant to House Rule 11, Clause 1, the chair may recess the committee at any point. While a roll call is not necessary to establish a quorum in official proceedings conducted remotely or with remote participation, the committee has made it a practice whenever there is an official proceeding with remote participation for the clerk to call the roll to help make clear who is present at the start of the proceedings. Members should say their names before announcing that they are present. This helps the clerk and also helps those watching the platform and the live stream who may be experiencing a few moments delay. At this point, I'll ask the clerk to please call the roll.
Chairman Scott.
Mr. Scott is present.
Mr. Grijalva.
Present.
Mr. Courtney.
Present.
Mr. Sablon. Ms. Wilson. Ms. Bonamici.
Suzanne Bonamici is present.
Mr. Chicano.
Mark Takano is present.
Ms. Adams.
Alma Adams is present.
Mr. DeSaulnier. Mr. Norcross. Ms. Jayapal.
Jayapal is present.
Mr. Morelli. Ms. Wild. Mrs. McBath.
McBath is present.
Mrs. Hayes.
Ms. Hayes is present.
Mr. Levin.
Levin is present.
Ms. Omar. Ms. Stevens.
Stevens is present.
Ms. Ledger Fernandez.
Leger Fernandez is present.
Mr. Jones. Ms. Manning. Mr. Mervan.
Mervan is present.
Mr. Bowman.
Mr. Bowman is present.
Sorry.
Mr. Pocan.
Pocan is present. I knew it was coming up.
Mr. Castro. Ms. Cheryl.
Cheryl's present.
Mr. Yarmouth. Mr. Espaillat. Mr. Mfume. Ranking Member Fox. Mr. Wilson. Mr. Thompson. Mr. Wahlberg.
Wahlberg is present.
Mr. Grossman. Ms. Stefanik. Mr. Allen. Mr. Banks.
Jim Banks present.
Mr. Comer.
Here.
Mr. Fulcher. Oh. Sorry, Mr. Comer. You're
That cannot be
All right.
justified by
Mr.
any
Fulcher.
particular.
Vulture's here.
Split one.
Mr. Keller.
Fred Keller is here.
Mr. Murphy. Mrs. Miller Meeks. Mr. Owens.
Burgess Owens present.
Mr. Good.
Good is here.
Mrs. McLean.
McLean is here.
Mrs. Harshbarger,
Hirschberger is here.
Mrs. Miller,
Mary Miller, present.
Mrs. Sparks,
Sparks is present.
Mr. Fitzgerald,
Fitzgerald here.
Mr. Cawthorn, Mrs. Steele. Chairman Scott, that concludes the roll call.
If
Still
the clerk
present.
if
I'm
the
sorry.
clerk could call the roll for those that did not answer the first time, I think several people I see on screen that did not appear to answer.
Mr. Sablon, Ms. Wilson, Mr. DeSaulnier, Mr. Norcross, Mr. Morelli, Ms. Wild,
I'm on mute.
Ms. Omar, Mr. Jones,
Thank you, Caleb, for your 12:30. I'm on it right now.
Ms. Manning, Mr. Castro, Mr. Yarmouth, Mr. Espaillat, Mr. Umfume, Ranking Member Fox,
Here.
Mr. Wilson, Mr. Thompson, Mr. Grossman, Ms. Stefanik, Mr. Allen, Mr. Murphy, Mrs. Miller Meeks, Mr. Cawthorn, and Mrs. Steele, I mark you as present.
Thank you.
Chairman Scott, that concludes it.
Mike, if you could give him 1 second, he will be able to answer you in just a moment.
Whoops,
You
who was that,
call
Dr.
his-
Fox?
Mr. Cawthorn just got to his desk. And
Okay,
if you'll call his name out again, he is just getting mic'd up. I believe he's
Okay.
on.
and I think Mr. Yarmouth is here. I don't think he got off of mute.
Yes, I'm here. I'm present, Mr.
Okay.
Chairman.
Okay,
thank
Mr.
you,
Yarmouth is marked as present. Mr. Cawthorn,
Yeah, present. I apologize for lateness. Thank you, Mariah.
No problem.
thank you.
Thank you. This is a remote markup pursuant to House Resolution 8 and the regulations there too. All microphones should be kept muted to avoid unnecessary background noise. Members are responsible for unmuting themselves when they are recognized to speak or when they wish to seek recognition. I also ask that members please identify themselves before they speak. Members shall be considered present for the proceedings when they are visible on camera, and they shall be considered not present when they are not visible on camera. The only exception to this is if they're experiencing technical difficulties, and they should inform the committee staff of such difficulty. However, members must be visible on camera to count toward the quorum and to vote, and the rules allow no exceptions to that. Moreover, there needs to be a verbal vote when there are votes so that both the clerk and the official reporter stenographer can hear it. A thumbs up or thumbs down without a verbal vote will not suffice. If any members are experiencing technical difficulties during the hearing, you should stay connected on the platform and make sure you are muted and use your phone immediately to call the committee's IT director whose number was provided in advance. Should the chair experience technical difficulty or need to step away, another majority member of the committee is hereby authorized to assume the gavel in the chair's absence. This is an entirely remote markup, and as such, the committee's hearing room is officially closed. Members who choose to sit with their individual devices in the hearing room must wear headphones to avoid feedback, echoes, and distortion, resulting when more than one person is on the same platform, sitting in the same room. Members are also expected to adhere to social distancing and safe health guidelines including the use of masks, hand sanitizer, and wiping down the areas before and after their presence in the hearing room. Now, amendments must be submitted electronically to the amendment repository pursuant to the instructions in the notice of amendment process that was distributed to all committee offices by the clerk with the markup notice. Amendments must be submitted to the repository before they are offered at markup. In order to ensure the committee's 5-minute rule is adhered to, staff will be keeping track of time using the committee's field timer. The field timer will appear in its own thumbnail picture and will be named 001_timer. There will not be a 1 minute warning, 1 minute remaining warning. The field timer will sound an alarm when the time is up. Members are asked to comply with the 5-minute rule and wrap up promptly when their time is expired. I now recognize myself to make an opening statement on the bills today. Today, the committee is marking up 3 bills that will take important steps to keep workers safe and ensure basic fairness for workers across the country. The 3 bills are H.R. 7, the Paycheck Fairness Act, H.R. 1065, the Pregnant Workers Fairness Act, and H.R. 1195, the Workplace Violence Prevention for Healthcare and Social Service Workers Act. The first bill, the Paycheck Fairness Act, would make significant strides in closing the gender pay gap. 58 years after signing the Equal Pay Act and over a decade after signing of the Lilly Ledbetter Fair Pay Act, the promise of equal pay for equal work remains unfulfilled. In fact, today is what they call Equal Pay Day, which symbolizes how much longer an average woman would have to work to earn what the average man made last year. Women still earn on the average 82 cents to the dollar compared to men, and this gap is far worse for women of color who make much less than their white male and female counterparts. The gap persists in nearly every line of work, regardless of education, experience, occupation, industry, or job title. The Paycheck Fairness Act would strengthen the Equal Pay Act and take additional steps to end gender-based wage disparities. Among other provisions, the bill will require employees, when defending equal pay claims, to prove that a pay disparity exists for legitimate business reasons. It will strengthen employee remedies by providing uncapped compensatory and punitive damages. It will ban retaliation against workers who discuss their wages. It makes it illegal for an employer to rely on an employee's wage history in the hiring process. And it allows employees to automatically participate in class action lawsuits against systemic pay discrimination unless they opt out. The second bill, the Pregnant Workers Fairness Act, would provide and guarantee basic workplace protections for pregnant workers. It is unacceptable that in 2021, pregnant workers can still be denied basic workplace accommodations that help them stay safe, stay healthy during their pregnancy. These accommodations, which can include water, seating, more frequent restroom breaks, or even temporary lifting restrictions, are not complex or costly. However, without the basic protections, too many pregnant workers are forced to choose between a healthy pregnancy and their paychecks. Now, our nation's workplaces have had several decades of experience providing reasonable accommodations under the Americans with Disabilities Act, so compliance should not be complicated. The Pregnant Workers Fairness Act clearly establishes a pregnant worker's right to reasonable accommodations and guarantees that pregnant workers can seek those accommodations without facing discrimination or retaliation. This bill passed the House with overwhelming bipartisan support last Congress, and I hope that we can work across the aisle again to pass the bill this year. The third bill, the Workplace Violence Prevention for Healthcare and Social Service Workers Act, will help protect our nation's caregivers from workplace violence. Today, healthcare and social service workers suffer disproportionately high rates of injuries from workplace violence. In 2018, healthcare workers accounted for 73% of all non-fatal workplace injuries and illnesses caused by violence. Recent data suggests that these workers are nearly 5 times as likely to suffer serious workplace violence injury than workers in other sectors. Unfortunately, the Occupational Safety and Health Administration, or Osha, does not have an enforceable workplace standard that requires employers to implement violence prevention programs. They all have all they have is voluntary guidance. For many employers, voluntary guidance are not enough. And OSHA currently does not have the tools to ensure that workers are adequately protected. It normally takes OSHA 10 to 20 years to issue a workplace safety standard. The Workplace Violence Prevention for Healthcare and Social Service Workers Act requires OSHA to implement an interim final standard within 1 year, and then a permanent standard within 42 months. It requires healthcare facilities and social service providers to develop and implement a workplace violence prevention plan. These three bills delivered on our promise to ensure that as our economy slowly recovers from the pandemic, all Americans will have access to safe workplaces where they can work free from discrimination. I now yield to the distinguished ranking member from North Carolina, Dr. Fox, for her opening statement.
Thank you, Mr. Chairman. All members of this committee agree on the fundamental premise behind each bill we are discussing today. Women should not be paid less than men for the same work. Pregnant workers deserve equal protection under the law, and all workers, especially those in healthcare and social services, deserve to be safe and protected at work. These basic underlying principles are not up for debate. That said, committee Republicans are not in the business of passing radical and prescriptive bills just to get flashy headlines and score political points. We are equally committed to promoting both fairness and strong policymaking. And when judged by these standards, each of today's bills falls short. In 1963 and 1978, federal protections against pay discrimination and pregnancy discrimination, respectively, were signed into law. Since then, the number of women in the workforce has skyrocketed, with female employees making up 50.4% of the pre-COVID workforce. As of 2015, a record 60% of pregnant women continued to work while pregnant with their first child. Without those necessary protections, women's workforce advancement would not have been possible. Democrats claim the Paycheck Fairness Act makes it easier for women to excel in the workplace, but it is a dangerous bill that will allow trial lawyers to fleece business owners around the country. Instead of treating pay discrimination allegations with the seriousness they deserve, the Paycheck Fairness Act is designed to make it easier for trial lawyers to bring more suits of questionable validity for the purpose of siphoning off unlimited paydays from settlements and jury awards, lining their own pockets and dragging women through tedious, never-ending legal proceedings. With regard to another bill before us today, the Pregnant Workers Fairness Act includes several improvements which we negotiated last Congress when a previous version of the legislation was considered. However, H.R. 1065 omits a current law protection for religious organizations, which could force religious employers to act against their deeply held beliefs. That is why I'll be offering a substitute amendment that will incorporate the full text of H.R. 1065 and ensure both pregnant workers and religious organizations retain the civil rights protections they deserve. We're also meeting today to discuss workplace violence in healthcare and social services workplaces. The Occupational Safety and Health Administration, OSHA, has recognized the hazards and risks that exist in these settings and is currently working to address this important issue through rulemaking. Addressing workplace violence in healthcare and social services settings is crucial, but forcing OSHA to issue a hasty regulation by allowing shortcuts in the proper regulatory process could have a devastating impact on the healthcare industry, which is currently responding to a once-in-a-century pandemic and is expected to be subject to new, burdensome OSHA regulations, from the Biden administration on COVID-19 in the future. Rather than enforce a rushed and prescriptive standard that does not include appropriate public feedback or analysis, committee Republicans believe workers deserve a responsible, workable, and thorough solution to this serious issue. This solution can only be reached by allowing Osha to issue a standard through the normal rulemaking process, which brings all experts and parties to the table. I will not criticize the intentions behind these bills, but good intentions do not necessarily breed good policymaking. I look forward to debating the Republican amendments that would be offered today, which offer meaningful improvements to the bills before us today. Thank you, Mr. Chairman. I yield back.
Thank you. Without objection, all other members who wish to insert written opening statements into the record may do so by submitting them to the committee clerk electronically by the end of today. House rules require that a copy of the measures be made available to members and the public at least 24 hours in advance. This was done electronically. We will now proceed with the consideration of the bill, H.R. 7, the Paycheck Fairness Act, for amendment. The bill was circulated and advanced electronically. The clerk will designate the bill.
Mr. Chairman, I have H.R. 7 to amend the Fair Labor Standards Act of 1938 to provide more effective remedies to victims of discrimination in the payment of wages on the basis of sex and for other purposes.
Thank you. And without objection, the first reading of the bill is dispensed with. Second reading without objection, the bill will be considered as read and open for amendment at any point, and any amendment offered shall be considered as read. Now recognize the gentlewoman from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman. I have an amendment in the nature of a substitute at the desk.
Clerk will
I have
designate.
amendment in the nature of a substitute to H.R. 7 offered by Ms. Bonamici of Oregon, code H.R. 7_ANS_V2.
Without objection, the amendment shall be considered original text and open for amendment at any point. The amendment in the nature of a substitute was distributed electronically in advance. I now recognize the gentlewoman from Oregon for 5 minutes to explain her amendment in the nature of a substitute.
Thank you, Mr. Chairman. The Equal Pay Act has been law for more than half a century, but equal pay for equal work is not a reality for too many women. In fact, today is Equal Pay Day, which symbolizes on average how long into 2021 women must work to make what men were paid in 2020. In 2021, women still earn on average 82 cents on the dollar compared to men. Women in nearly all occupations, regardless of education, experience, industry, or job title, experience a wage gap. The wage gap also disproportionately affects women of color. Black women earn an average of 63 cents on the dollar, Native women earn an average of 60 cents on the dollar, and Latina women earn an average of 55 cents on the dollar compared to white men. And the COVID-19 pandemic has only made these realities harsher. According to a recent report from the Center for American Progress, the pandemic has set women's workplace equality back by nearly a decade. Gender-based wage discrimination is an injustice to millions of working families, and closing the wage gap is an economic imperative. I am an original co-sponsor of the Paycheck Fairness Act because it will help confront and eliminate loopholes that have allowed gender-based wage discrimination to continue. Last week, I was honored to chair a joint subcommittee hearing on workplace discrimination. We heard witnesses describe how insufficient enforcement and loopholes in the Equal Pay Act and Title VII of the Civil Rights Act result in barriers to detecting wage discrimination and holding discriminating employers accountable. For example, a lack of easily accessible data on hiring and wages has made it difficult to detect, let alone prevent, wage discrimination. The Paycheck Fairness Act includes a provision to require the Equal Employment Opportunity Commission and the Department of Labor to collect information from employers on compensation disaggregated by sex, race, and nationality to help detect pay discrimination. Furthermore, Even when wage discrimination is discovered, women still face significant barriers to fulfilling the heavy burden of proof for holding discriminating employers accountable. Workers are required to identify a specific employee of the opposite sex in a substantively equal position who is paid more in the same physical location. The Paycheck Fairness Act would shift the burden of proof and require employers to prove that a pay disparity exists for legitimate reasons. It will also protect workers who discuss their wages from retaliation, and it will prohibit employers from relying on the salary history of prospective employees during the interview and hiring process. Proposals to address pay inequities have been successfully implemented across the country. For example, in my home state of Oregon, the Oregon State Legislature passed a bipartisan bill to strengthen equal pay protections, prohibit employers from seeking salary history for job applicants, and expand support for workers who have been victims of wage discrimination. These are laudable achievements, but it's time for Congress to take a leadership role in addressing persistent wage discrimination nationwide. My amendment in the nature of a substitute updates the definition of sex in the Equal Pay Act to be consistent with the Supreme Court's ruling in Bostock by clarifying that sex includes sexual orientation and gender identity. It would strengthen the non-retaliation provisions by making sure that workers cannot be retaliated against for opposing unlawful pay discrimination and providing compensatory and punitive damages if they do face retaliation. It also clarifies that both the EEOC and OFCCP have joint enforcement authority over the Equal Pay Act, and it modernizes the OFCCP's pay data collection requirement. This amendment in the nature of a substitute also strikes the bill's findings section and clarifies that the EEOC and OFCCP will coordinate in the implementation of the National Pay Equity Award. By addressing the problematic loopholes in current law, empowering workers to better detect and combat wage discrimination, and creating mechanisms for better pay data transparency, we can restore the original intent of the Equal Pay Act and finally make equal pay for equal work a reality. I urge all of my colleagues to support this in the nature of a substitute, and I yield back the balance of my time.
Thank you. Gentlelady's time has expired. Does anyone else seek recognition?
Mr. Chairman.
Ranking Member, Dr. Fox.
Thank you, Mr. Chairman. I ask to be recognized for 5 minutes.
Gentlelady is recognized for 5 minutes.
Thank you. The Paycheck Fairness Act offers no new protections against pay discrimination. It's worth repeating. The Paycheck Fairness Act offers no new protections against pay discrimination. Committee Republicans have voiced legitimate concerns about the contents of this bill, all of which have been ignored by the majority. Simply put, this bill is for and about the well-being of trial lawyers, not working women. Pay discrimination is repugnant and already illegal. We must hold bad actors accountable. But this bill doesn't do that. Instead, what we have before us is just another bill rewarding Democrat special interests at the expense of workers and job creators. We have the most varied and complex workplaces in the world. Before the onslaught of COVID-19, women were earning merited paychecks in record numbers. I don't see how opening the gates to limitless, frivolous lawsuits is going to help anybody. The Paycheck Fairness Act will make it extraordinarily difficult, but not impossible, for employers to defend, if not impossible, for employers to defend against pay discrimination suits, even when pay differences are the result of legitimate factors like experience, education, and performance. It also puts at risk the Christmas bonus, which many employees rely on to give their families the holiday season they deserve. Limiting ways that employers can compensate hardworking employees, especially during a pandemic, harms both employers and employees, as both try to navigate what increasingly amounts to government oversight of private, mutually agreed upon decisions. Pay discrimination cases are serious and deserve to be treated as such. We need to focus on policies that will create more opportunities for all workers, women included. This bill does not do that. We need to see this bill for what it is, a trial lawyer payday. No one, especially those women facing already illegal pay discrimination, stands to gain much, if anything, from this legislation. Should my Democrat colleagues wish to discuss additional policies which will foster the advancement of women in the workplace, we can discuss legislation that bolsters the gig economy, safely reopen our schools and businesses, and promotes career and technical education, to name a few. Freedom is difficult to legislate because it requires the federal government to relinquish some of its power. My Democrat colleagues would rather impose radical and unworkable policy under the guise of, quote, progress, end quote, rather than foster environments where individuals are empowered to make the decisions that are best for them. Mr. Chairman, I have worked very hard all my life to promote equality and fairness for women. I recognize unfairness when it happens, and I recognize policies that help women. This bill does not do that. Thank you. I yield back.
Thank you. Does anyone else seek recognition? Let me see. Ms. Jayapal,
Thank you, Mr. Chairman. I move to strike the last word.
and ladies recognized for 5 minutes.
Thank you, Mr. Chairman. We're here today to deliver transformative change and gender equity for millions of essential workers. Today, that means passing not one, but 3 groundbreaking pieces of legislation that will strengthen the right of all workers to equal pay for equal work and dignity, safety, and security on the job. Throughout this pandemic, women and mothers in particular have been pushed out of the workforce in alarming numbers as they've struggled to juggle their careers with caretaking. Women have experienced 1 million more job losses than men during the recent recession. And the disparities are even greater for women of color. In December of 2020, Black, Hispanic, and Asian women accounted for all of women's job losses that month, while 154,000 Black women dropped out of the labor force entirely. Recent data show that 88% of first-time mothers worked during their last trimester, while 62% of workers have witnessed pregnancy discrimination on the job. Behind these statistics lie an avalanche of anxieties and humiliations that pregnant workers have endured in this country for far too long. I'm proud to say that since 2017, pregnant workers in my home state of Washington have been entitled to reasonable accommodations, including additional bathroom breaks, modifications to workplace food and drink policies, and other basic protections. Pregnant workers across this country deserve the same rights. That's why we're advancing the Pregnant Workers Fairness Act to guarantee the rights of pregnant workers to reasonable accommodations and protections from discrimination at work. I'm excited to build on that important progress by also passing the Paycheck Fairness Act today to ensure that women receive equal pay for equal work. Even before the pandemic, women faced wage discrimination in virtually every sector of our economy. Young women who were college graduates in the same jobs and with the same qualifications as their male peers earned 12.9% less in 2019, while 2/3 of minimum wage earners are women. BIPOC women face even more detrimental economic impacts from race and gender wage gaps. The double burden of racism and sexism not only harms BIPOC women and their families' economic security, it also contributes to substantial financial losses over time. The race and gender wage gap are why full-time working women of color will lose more than $1 million in income over a 40-year career. The Paycheck Fairness Act is about ensuring equality for women across our society. Women make up half of the full-time labor force in our nation and are the backbone of the US economy. We cannot build back better without putting equal pay for all women at the forefront of our national agenda. Last, I'm proud to support the Workplace Violence Prevention for Healthcare and Social Service Workers Act. During this pandemic, millions of our nation's caregivers, nurses, social workers, and others in this majority women workforce have put their lives on the line to care for us and our loved ones. And yet these courageous workers suffer from workplace violence at the highest rates of any profession. Just last year, the Bureau of Labor Statistics reported that healthcare and social service workers were nearly 5 times as likely to suffer a serious workplace violence injury than workers in other sectors. We must protect healthcare and social service workers and honor them for their courage. It troubles me that my Republican colleagues would call these bills for gender equity dangerous. That could not be farther from the truth. What is dangerous is the status quo. These 3 bills are necessary to set a critical foundation for a recovery centered around gender equity and workers' dignity. I look forward to passing these bills through our committee and through the House. And Mr. Chairman, I yield back.
Thank you. Anyone else seek recognition? Mr. Gentleman from Michigan, Mr. Levin. Wait a minute, hold on a minute. Say again. Okay, gentleman from Michigan, Mr. Levin.
Thanks, Mr. Chairman. I move to strike the last word.
You gentleman's recognized for 5 minutes.
Mr. Chairman, it's ridiculous that women still make on average 82 cents for every dollar earned by their male counterparts. This discrepancy gets even wider for women of color, with African American women earning 63 cents and Latinas 55 cents for every dollar a man makes. The gender pay gap is a social justice issue that impacts our entire nation. It harms women and whole families. Yes, those women's men folks, and of course their kids. And it harms the economy as a whole. We must bring it to an end. The idea that that's a dangerous thing to do is beyond words to me. Pay discrimination has persisted due to the systemic abuses and sexist tropes that prevent women from earning the same as men. I'm glad we're considering the Paycheck Fairness Act, because it's long past time to update our laws to deal with the realities that women face in the workplace of today. This bill includes common sense provisions to fight gender-based wage discrimination. These provisions include ensuring transparency by banning retaliation against workers who discuss wages, putting the onus on employers to prove that pay disparities exist for legitimate job-related reasons and are not based on gender, and finally, making it easier for women to stand together to fight for their right to equal pay in the courtroom. The gender pay gap should not be a partisan issue, and it's not one of ideology. It's a simple matter of what is right and what is wrong. I urge all of my colleagues to vote for this important and bipartisan piece of legislation, and I yield back.
Thank you. Gentleman's time has expired. Anyone else seek recognition? Gentlelady from New Jersey, Ms. Sherrill.
Thank you, Mr. Chairman. I move to strike the last word. Thank you again.
Gentlelady's recognized.
Thank you. Thank you again, Mr. Chairman. Thank you, Ranking Member Fox, for allowing me to address the Education and Labor Committee this afternoon in support of this really historic legislation. It's timely that we're having this hearing on March 24th, Equal Pay Day. For too long, we've been having the same continuous conversations about women in the workforce and pay equity. This past year has been particularly difficult for women in the workforce, particularly mothers. Throughout the pandemic, women have largely shouldered the burden of childcare, risked their lives as frontline essential workers, and unfortunately have seen disproportionate impacts from the economic fallout. Since the pandemic began, almost 5.4 million women have lost their jobs and still not recovered them, which is nearly 1 million more than seen by men during the same time period. This is close to double the level of job loss seen during the worst month of the Great Recession, when women lost 2.8 million jobs. By passing the American Rescue Plan, we laid the groundwork to ensure that we return our economy to full employment as fast as possible. A key element will be helping get women back to work. Indeed, independent estimates project that the ARP will create 4.3 million new jobs by the end of 2021. However, I fear that even if we are successful in supporting millions of women to re-enter the workforce, they'll still be dealing with the effects of long-standing disparities. Unless we take substantial action now, the jobs that they will return to will continue to pay only 80 cents for every dollar that men make for the exact same work. That gap will be bigger for women of color. For too long, discrimination against women in the workplace has prevented women from achieving the highest levels of leadership in both the private and public sectors, and it has collectively taken hundreds of billions of dollars in wages and benefits from working women across the country. Based on median annual earnings, women in the 11th District of New Jersey who work full-time make on average around $20,000 less than men. Furthermore, of the 500 largest companies in the United States by revenue, only 33 have female CEOs, and even this was a large improvement compared to recent years. Congress recognized this reality when they passed the Equal Pay Act in 1963, but there is more work to do. The gender wage gap has shrunk since then from about 60% in 1980 to about 80% today. But is that really a success when such a large gap still exists and the gap for women of color remains even wider? The Paycheck Fairness Act will finally make true on the promises of the Equal Pay Act. By enhancing enforcement of that legislation, strengthening federal agency pay data collection, and prohibiting employers from relying on employee salary history, this bill has the ability to significantly reduce discrimination in the workplace. So I am so proud to be co-sponsoring and voting in favor of this legislation today. I encourage all of my colleagues on both sides of the aisle to do the same, and I yield back. Thank you, Mr. Chairman.
Thank you. Does any other member wish to speak on the member nations with substitute? If not,
Mr. Chairman? Alma Adams.
Gentlelady from North Carolina, Dr. Adams.
Thank you. I move to strike the last word, Mr.
Ladies
Chairman.
recognized for 5 minutes.
Colleagues, it's 2021, but women still are subjected to unequal, unfair compensation in the workplace. I continue to say that working hard is not enough if you don't make enough. So women don't make enough if they make less than men for the same work. Today, on average, women, as you've heard, earn 82 cents on the dollar compared to all men. This reality, this wage gap is even worse for women of color. You've heard it. Black women earn an average of 63 cents on the dollar, Native American women 60 cents, and Latino women 55. Now, the wage gap persists in nearly every line of work, regardless of education, regardless of experience, occupation, industry, or job title, and that is just not acceptable. For decades, from the North Carolina House to the US House, I've been fighting to close the gender wage gap. 58 years have passed since the Equal Pay Act was enacted, and it's been 10 years since President Obama signed into law the Lilly Ledbetter Fair Pay Act, yet the promise of equal pay for equal work remains unfulfilled. The Paycheck Fairness Act is an opportunity for Congress to strengthen the Equal Pay Act, bolster the rights of working women, and put an end to this gender-based wage disparity once and for all. This Paycheck Fairness Act would require employers to prove that pay disparity exists for legitimate reasons. It would ban retaliation against workers who discuss their wages. It would allow more workers to participate in the class action lawsuits against systemic pay discrimination. It would prohibit employers from relying on the salary history of prospective employees, and it would develop wage data collection systems and provide assistance to business to improve equal pay practices. This is a Pay Equity Fairness Day. And so the House passed this legislation with support of 7 Republicans in the 116th Congress. And so we look forward to passing it again this year and today. We cannot continue to rob nearly half of our nation's workforce of the wages they deserve, nor can we continue to force women to work for more just to be paid fairly. I yield back, Mr. Chairman.
Thank you. Gentlelady's time has expired. Does any other member seek recognition?
Mr. Chairman?
Gentlelady from North Carolina, Ms. Manning.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized for 5 minutes.
I'm pleased to speak in favor of the Paycheck Fairness Act. Too often, women are disadvantaged in the workplace. This remains true despite the fact that women make up over 50% of the American workforce, or at least they did before the pandemic. I'm proud to co-sponsor the 3 bills we're marking up today because they will help ensure that women are treated fairly in the workplace. The Paycheck Fairness Act addresses gender-based discrimination and prohibits retaliation against workers who discuss their wages. It's fitting that we're marking up this piece of legislation on Equal Pay Day, the date that signifies the additional time required for a woman to earn the same amount as a white male colleague earned last year. The existence of Equal Pay Day, a full 3 months into the new year, illustrates the need for the Paycheck Fairness Act. We must do more to ensure that women earn fair pay for fair work. I'm also pleased to speak in favor of the Pregnant Workers Fairness Act. This act prohibits discrimination against pregnant workers by requiring employers to make reasonable accommodations for pregnant workers or those affected by childbirth. This bill builds on the Pregnancy Discrimination Act of 1978 to ensure that discrimination is not only prohibited in the hiring of employees, but also in how employees are treated in the workplace. This important legislation is critical to ensuring that female employees are able to raise their families and excel at work. This issue is something I have personally experienced. I worked through all 3 of my pregnancies. However, I experienced dangerous premature labor during my 3rd pregnancy and was required to go on bed rest to avoid premature delivery and risk the life of my child. I was fortunate to have an employer who was willing to accommodate my medical needs. Thanks to the accommodations made by my employer, I was able to deliver a healthy baby. My career was not interrupted, and I was able to provide value to my employer when I was able to get back to work safely. The goal of this bill is to ensure that all pregnant workers have the right to the same accommodations I was able to enjoy, to deliver healthy babies while maintaining their jobs. Finally, I'm pleased to speak in favor of the Workforce Violence Prevention for Healthcare and Social Service Workforce Act. This bill requires employers in the healthcare and social services industries to develop and implement workplace violence prevention plans to protect nurses, physicians, social workers, emergency responders, and others. This bill helps to ensure that employees are safe at work. I'm pleased to support all 3 of these bills. They address important needs of fairness, discrimination, and safety. They will allow us to have a stronger and more productive workforce. And I yield back.
Thank you. Does anyone else seek recognition? Gentleman from California, Mr. Chicano. Gentlelady from Connecticut, Ms. Hayes.
Yes.
Gentlelady's recognized for 5 minutes.
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady's recognized for 5 minutes.
From the start of this pandemic, my colleagues and I have sounded the alarm that the economic impacts of COVID-19 would not be felt equally. This is especially true of women's economic experiences throughout the past year. Connecticut women have been disproportionately impacted by our national economic turmoil. 48% of our female workers work in industries deemed essential. Women-owned businesses, many in the healthcare, social assistance, education services, and retail industries, have been most at risk through the pandemic. And women have outpaced men in unemployment claims for the first time in Connecticut's history. Women of color were especially hurt, representing more than 1/3 of unemployment claims filed by women throughout the state. The moral outrage that these statistics cause should be even further amplified with the knowledge that women make up nearly 65% of all essential workers nationally. They are over half of our essential grocery, convenience, and drugstore employees, over half of all essential building cleaning staff, over 75% of all essential healthcare workers, and over 85% of all essential workers in childcare and social services. Women have carried this nation on their backs through one of the darkest times in American history, even as familial and childcare duties piled on top of their already full plates. The urgent question that raises is, what do we believe we owe these essential workers? Are we going to tell female workers in essential industries that protecting them from pay discrimination is simply too much to expect, even when they have put the lives of themselves and their families on the line for the past year to maintain the core functions of our nation? Are we going to tell them that we accept the fact that they stand to lose $400,000 in lifetime earnings despite doing the exact same work as their male counterparts? Are we going to tell women of color who represent disproportionate numbers of essential workers that it is not a problem that they face increased wage discrimination on the basis of their gender and race? The obvious answer to all of these questions is a resounding no. But our promises to essential workers, our proclamations of their heroism, and our constant expressions of gratitude are hollow when we cannot even promise them an equal shot at economic success. The Paycheck Fairness Act provides the tools women need to be sure that they will be paid what they deserve. It will prohibit workers from paying women less than they are worth simply because another employer underpaid them in the past. It will ensure women can talk to their colleagues about their compensation, so it does not take a decade for them to learn they have been discriminated against. And it will allow women to participate in class action lawsuits to challenge pay discrimination that they may experience. The contributions of women of our nation have never been clearer. This bill honors women's work and ensures they are able to reap the wages they deserve. Thank you, Mr. Chair, and with that, I yield back.
Thank you. Does anyone else seek recognition? Mr. Takano, gentleman from California, Mr. Takano.
Yes, Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you. Mr. Chairman, I'm proud to co-sponsor this legislation, which is a critical step in ending gender-based wage discrimination and lifting women and families out of poverty. It is also very telling this important legislation has been co-sponsored by every single Democrat in the House of Representatives. Women still make only 82 cents on average for every dollar earned by her male counterpart. That gap is a persistent reality for women in the workplace, particularly women of color. Compared to white men, Native, Hawaiian, and Pacific Islander women are paid 63 cents for every dollar. The disparities for women of color are alarming. If women were paid the same as men, the poverty rate for all working women would be cut in half, and the poverty rate for working single mothers would be cut by nearly half. On this equal pay day, it is imperative that we highlight the contributions women make day in and day out. Despite decades of the Equal Pay Act being enacted, it could not be more apparent that incentives alone will not suffice to compensate women equal pay for equal work. There are many critical provisions in this legislation, but I'm pleased that the bill includes a ban on retaliation against workers who discuss their wages. And yes, women do need their day in court. They do need recourse to have the law enforced. They do need legal remedies, and that means their day in court. Mr. Chairman, I yield back.
Thank you. Gentleman's time has expired. Does anyone else seek recognition? Gentlelady from Pennsylvania, Ms. Wild.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized for 5 minutes.
Thank you. I appreciate the opportunity we have here today on Equal Pay Day to send a strong message to America's women that equal work deserves equal pay. It's that simple, and we won't accept anything else. I am proud to co-sponsor the Paycheck Fairness Act and to have supported this bill on the House floor last Congress in a bipartisan vote. Casting that vote, I thought of my mother, who worked an entire career at a time when that was rare for a woman and who was a lifelong union member. I picketed with her on the picket line at one time, and she taught me that justice only comes when working people band together and demand it. And in casting my vote last year, I also thought of my daughter, who is at the very beginning of her career, and the future of opportunity and equality that I want her to experience. But we know that women face challenges in their workplaces to achieving a fair paycheck, and we face headwinds in closing the overall pay gap in our economy. Last September, the Census Bureau released data that show our country has made no progress in 2018 or 2019 in closing the overall wage gap. Full-time working women still earn just 82 cents for every dollar a man makes. That number is even lower for women of color. 63 cents on the dollar for Black women, 60 cents for Native women, and 55 cents for Latino women in 2019. The wage gap hits working mothers hard as well. The National Women's Law Center published a report in May 2020 that found that mothers working full-time earned 70 cents on the dollar that fathers earned. Each and every woman deserves a fair paycheck. But more than that, when we restrict the potential and opportunity of women, we restrict the potential of our communities and our economy. Our work towards a stronger economy and a fairer society starts today by approving this bill to ensure that women have the dignity and justice of equal pay for equal work. I urge my colleagues to join me in this fight. And with that, Mr. Chairman, I yield back.
Thank you. Does anyone else seek recognition? It appears that no further discussion on the amendment nature of a substitute is desired. The committee will now move to consideration of amendments. Does any member seek to offer an amendment? Gentlelady from New York, Ms. Stefanik.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
I have amendment to the amendment in the nature of a substitute to HR 7 offered by Ms. Stefanik of New York, code STEFNY_111.
Thank you.
The gentlelady is recognized for 5 minutes to speak on behalf of her amendment.
Thank you, Mr. Chairman. Prior to the COVID-19 pandemic, there were over 77 million women in the workforce, the most in our nation's history. Of the 2 million jobs created in 2019, 53% went to women. And as we know, women are graduating from college at a higher rate and are increasingly their family's primary breadwinner. Despite all of these positive economic indicators, there remains evidence that in some cases, women do not earn the same levels of compensation as men. Republicans support equal pay for equal work, and we owe it to women to constructively engage on this important issue and put forward solutions. Democrats have put forth a bill that prioritizes trial attorneys and government regulation over women and families' economic empowerment. The Democratic bill would require data disclosure to the EEOC that collects compensation data broken down by the sex, race, and national origin of employees, while for the first time also tracking the hiring, termination, and promotion data of those employees. These intrusions into the operations of private business would add compliance costs exceeding $700 million per year. On top of these onerous new requirements, HR 7 is a giveaway for trial lawyers. By changing class action lawsuit formation from opt-in to opt-out, America's businesses will need to prepare for an onslaught of frivolous lawsuits, which now will be open to unlimited compensatory and punitive damages. The bill establishes an impossibly high burden of proof for employers defending the legitimacy of pay differentials between employees. And we need to recognize that in today's modern economy, 40% of small businesses are run by women. This bill would make it harder for these women small business owners. This issue is too important to leave to partisan political solutions. My amendment, the Wage Equity Act, offers a stark contrast to the approach laid out by HR 7. We looked to innovation in the states to find bipartisan policies that are supported by both Republicans and Democrats, signed into law by Republican governors. Proof that equal pay for equal work is not a partisan issue and that Republicans are leading the way on women's economic empowerment. The Wage Equity Act is reflective of the modern workforce and supports the empowerment of women in today's economy. America's businesses, in particular our small businesses, which are the backbone of our economy, seek to do right by their employees. In recognition of this, the Wage Equity Act creates a self-audit system for voluntary pay analysis by businesses. Under our proposal, a business could and should undergo a pay analysis to proactively rectify any pay disparity should it exist. By creating an environment of consistent self-audit, we can further empower businesses to do what they already seek to do, doing right not only by their employees, but by the law. I believe that an individual should be able to negotiate employment based upon their qualifications and merit for the position. And I also believe that the victim of wage discrimination at any point in their career should not have to have this discrimination follow them to their next job and the next job after that and compound through the rest of their career. That's why my amendment protects the employee's right to not disclose their salary history during the job interview process unless they wish to voluntarily disclose it. We must acknowledge the compounding impact of wage discrimination on a person's career and be willing to discuss ideas to free employees from this burden. At the same time, we cannot erode the necessary negotiation that takes place in a job interview or ignore the role wage figures can play in the advancement of an individual through their career. So the Wage Equity Act protects the ability for an employee and their prospective employer to have a wage expectation conversation, an important part of any negotiation. My amendment protects employee ability to discuss compensation with their colleagues while giving employers the ability to set reasonable limitations on the time, location, and manner of this activity to prevent employees from harassment. Furthermore, the Wage Equity Act seeks to put women on equal footing with men as they start their careers. The legislation creates a grant program targeted towards women in college and career tech programs to provide negotiation skills education. Lastly, my amendment directs the GAO to study the manager's gap. We know that the wage gap greatly expands for women after they return to the workforce following parental leave. We must have a clearer sense of the impact leave during this time will have on an employee's future earning and opportunity potential. These are common sense proposals that are supported by Democrats and Republicans across this country alike, and I encourage my colleagues to reject this partisan government approach and support practical bipartisan solutions that improve the existing law of the land, equal pay for equal work. Thank you, Chairman Scott, and I yield back.
Thank you. Gentlelady's time has expired. Does anyone seek recognition? The list I have starts with the gentleman from Michigan, Mr. Levin.
Thank you so much, Mr. Chairman. I rise to speak in opposition to the amendment.
The gentleman's recognized for 5 minutes to strike the last word.
Thank you. Mr. Chairman, I'd like to speak in particular about the employer defense. The Paycheck Fairness Act would not eliminate the factor other than sex defense. It just makes it clear what the deal is. The Paycheck Fairness Act clarifies that any factor other than sex that an employer defense uses must be a bona fide job-related factor and that it's required by business necessity. That's all. It's common sense. Under the Paycheck Fairness Act, the employer's pay practices will be scrutinized as they are under Title VII to determine whether they actually serve a legitimate business purpose. The any factor other than sex employer defense should not be a catch-all to effectively allow employers to discriminate at will. And the point is simply that it should be based on an actual bona fide business factor like education or training or level of experience. Requiring an employer to show that a job is consistent with business necessity applies a term that's already specifically defined in civil rights law and thus provides workers and employers with a clear and known legal standard for assessing pay disparities. The problem we face, Mr. Chairman, is that courts have interpreted the any factor other than sex criteria in ways that create not only a lack of clarity regarding employers' obligation and workers' rights, but rank unfairness. Many courts have found that any factor other than sex employer defense doesn't even have to be business related or related to the particular position in question. Let me give you an example. A male worker's stronger salary negotiation skills or higher previous salary has been accepted by courts as legitimate employer defenses for pay disparity, even if those factors themselves may be based on sex and involve rank sexism, in fact. Courts have even accepted employers' arguments to pay a male employee a higher salary to prevent him from leaving or to recruit him, or the old saw, to support his family, as if women don't have families to support. This type of stereotyping is backwards and it undermines women's fight for equality. Finally, the Paycheck Fairness Act would not allow employees to determine their employer's business purpose. The Paycheck Fairness Act requires employees to demonstrate that there are alternatives to meet the employer's business needs. And it wouldn't require employers to adopt irrational or cost prohibitive pay practices. Under Title VII, courts have made clear that a cost prohibitive employment practice would not be an equally effective alternative. So bottom line, Mr. Chairman, we've got to tighten up the any factor other than sex criteria. This amendment doesn't do that. It takes that out of the bill, and therefore we need to reject it. Thank you. I yield back.
Thank you. Does anyone on the minority side seek recognition? If not, the next on my list is the gentlelady from Michigan, Ms. Stevens.
Thank you, Mr. Chair. I'd like to strike the last word on this amendment.
Recognize 5 minutes to strike the last word.
I'm pleased to see that Republican colleagues are recognizing that employers' reliance on prospective employees' salary history can carry past gender discrimination into a new job. Well, unfortunately, what we're getting with this amendment, it still allows employers to impose harmful restrictions on potential employees or on employees, particularly based on gender. So relying or even opening up the window to rely on a job applicant's salary history in the hiring and pay setting process assumes that prior salaries are an accurate measure of an applicant's experience and achievements and not the product of discrimination, bias, or other factors. It also doesn't take into account that people might be switching careers. They might be working a different job. We know that women, as it is well articulated in this legislation that we're voting on here today, we know that women tend to earn less based on the professions that they go into at an overwhelming rate. So if you are switching professions and they are relying on the salary from that previous job, that could also be detrimental. I know I have seen this very close up in my career, much to my outrage and dismay. And if we're going to be successful with the Paycheck Fairness Act, we need to be really clear about pay history and reliance on salary history. So even when it's voluntarily disclosed, to select job applicants and to set new hires' pay based on previous salary history will tend to perpetuate this gender and race-based disparity in the workforce. And look, the Harvard Business Review, it found a significant percentage of employers who conduct pay equity audits found that relying on that salary history is a key driver of gender pay gaps. So we got to end this once and for all, which is why I am submitting this rebuttal and certainly taking a look at not only salaries, but bonuses, commissions, these other pay things that go into place. The reliance on worker salary history just has a disproportionate and negative effect. So let's do this right. Let's pass the Paycheck Fairness Act. And I urge all my colleagues to oppose the amendment. And Mr. Chair, I'm going to yield back the remainder of my time. Thank you.
Thank you. Gentlelady's time has expired. Does anyone on the minority side seek recognition? If not, the next on my list is the gentlelady from Connecticut, Ms. Hayes.
Thank you, Mr. Chair. I speak in opposition to Congresswoman Stefanik's amendment in the nature of the substitute. The minority's amendment is unclear at best regarding worker protections from discrimination on the basis of salary history and detrimental at worst. While the Paycheck Fairness Act clearly states that an employer can only utilize an employee's salary history in wage determination, if it is voluntarily disclosed after an offer is made. The minorities amendment removes all protections if an employee voluntarily discloses their salary at any point in the hiring process. We know this will hurt workers. When an employer places heavy weight on the salary history of an employee when determining the rate for a new position, they are essentially saying that if you were undervalued before, you're going to be undervalued again. Unsurprisingly, this has a disproportionately negative impact on women and people of color, who are typically paid lower wages than white non-Hispanic males. According to a recent study by Harvard Business Review, a significant percentage of employees who conduct pay equity audits found that relying on applicants' salary history is a key driver for gender pay gaps within their companies. The practice impacts not only salaries, but bonuses, commissions, and any other subsequent payments based on that initial salary or wage rate. The amendment in the nature of a substitute will provide a loophole for employers to carry on previous discrimination throughout workers' careers. I urge my colleagues to oppose this amendment. And with that, Mr. Chair, I yield back.
Thank you. Gentlelady's time has expired. Does anyone else seek recognition? Next on my list is the gentlelady from New Jersey, Ms. Cheryl. Gentlelady from New Jersey, Ms. Cheryl, seek recognition. Gentleman from New York, Mr. Morelli.
Thank you, Mr. Chair. I move to strike the last word and speak in opposition to the amendment. I wanted to particularly focus on one of the provisions of the measure and the amendment, and that relates to the self-evaluation safe harbor, which essentially provides that an employer who conducts a compensation self-evaluation audit, and if such audit reveals illegal differentials in pay, they can take reasonable steps to address these differentials and then could avoid liability for liquidated, compensatory, or punitive damages, and would be only liable for the back pay of an employee who is not paid correctly. So I'm not going to lie, one of my, and this will demonstrate what a kind of a nerd I am, but one of my hobbies is watching classic movies on Turner Classic Movies. I like old movies, but one of the things that's shocking about them is the treatment of women in the workplace in the 30s, the 40s, the 50s, which led to the Equal Pay Act. But not only is that shocking, it also reminds you of how far we have yet to come, and how in the last 50 years, we have not been able to adequately resolve this issue. And my colleagues have done, I think, a terrific job of identifying the continued gaps in equity, particularly among women of color. And that's why we're here today. That's why I'm a proud co-sponsor of this, as well as my Democratic colleagues. But the amendment using self-audits is really a little bit akin to the fox guarding the hen house. So it would allow employers to game the system. When they fear impending litigation, they use self-audits as a discovery tool, as though they didn't know what they were doing in the first place, that you'd somehow have to audit to determine whether or not you yourself are taking or using discriminatory practices. So not only do I find it disingenuous at best, it is a tool to avoid liability here. And I think what we've learned after 50 years is that many employers are still not paying equal pay for equal work. And there's little reason to believe all the incentives that we've put in place, not to mention just social pressures, haven't led to a place where we have pay equity. So I strongly object to this provision. I think, again, relying on those who are the offenders and who, in the face of all the work that we have done and all the conversation we've had in this country over the last decades, have not taken steps to ensure pay equity. I think suddenly giving them another tool to avoid liability and to use at the last minute a self-auditing process undermines everything that we attempt to do. And so I strongly object to the amendment in the nature of a substitute, or substitute in the nature of amendment, and yield back the balance of my time.
Thank you, gentlemen. Time's expired. Anyone on the minority side seek recognition? If not, the gentlelady from Georgia, Ms. McBath.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized for 5 minutes.
I'm going to be very, very brief, and I have to unequivocally say that I express the same sentiments that all of my colleagues have spoken to just a little bit earlier prior to me. But, you know, we know that employers' reliance on workers' prior salary definitely has disproportionately a negative impact on women, which we've talked about that already, but also people of color. And they're typically already paid lower wages than white non-Hispanic men. And I myself have been a victim of that as well. So nothing in this bill stops the employer from asking about a candidate's salary expectations. And therefore, once again, I oppose this amendment, and I yield back the balance of my time.
Thank you. Gentlelady's time has expired. Anyone seek recognition on the minority side? If not, gentlelady from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman. I move to strike the last word and speak in opposition to the amendment.
Gentlelady's recognized for 5.
Thank you, Mr. Chairman. And I'm concerned about the amendment overall for the reasons stated by my Democratic colleagues. But I want to follow up particularly on Mr. Morelli's comments and address concerns about the self-audit provisions, although I'm doing mine without a movie analogy, I'm sorry. This amendment would essentially allow employers to use self-audits to shield discovery and limit liability for gender-based pay discrimination, which is exactly what we're trying to stop. This amendment would permit employers to delay taking remedial action and also avoid having their discriminatory practices be discoverable or admissible if there is a legal action. And that's true even if the self-audit finds yet does not actually address gender-based pay discrimination. I want to note that the Paycheck Fairness Act does acknowledge the value of recognizing employers who do not discriminate as part of a comprehensive strategy by establishing a national award for pay equity in the workplace. And that's designed to help encourage employers to proactively comply with the Equal Pay Act. So I urge my colleagues to oppose this amendment, and I yield back the balance of my time.
Gentlelady's time has expired. Does anyone else seek recognition? Did the gentlelady from New Jersey seek recognition on the amendment? Not sure she's, well, anyone else seek recognition? If not, the question is on the amendment. All who favor the amendment will say aye.
Aye. No, sorry.
Aye.
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 No.
All opposed will say no.
No.
No. Noes appear to have it. The noes appear to have it.
Mr. Chairman, I request a recorded vote.
Recorded vote is requested. And that vote will be rolled. Are there other amendments to the bill? If there are no other amendments, the question is on the reporting of the bill, and that will be rolled till the end. The next order of business will be HR 1065. The first reading of the bill. The clerk will report the bill.
Mr. Chairman, I have HR 1065 to eliminate discrimination and promote women's health and economic security by ensuring reasonable workplace accommodations for workers whose ability to perform the functions of a job are limited by pregnancy, childbirth, or a related medical condition.
Without objection, the first reading of the bill is dispensed with. And the second reading, without objection, the bill will be considered as read and open for amendment at any point. Any amendment shall be considered as read. Now recognize myself to offer an amendment in nature of a substitute, which is at the desk, and the clerk will designate the amendment in the nature of a substitute.
Mr. Chairman, I have amendment in the nature of a substitute to HR 1065 offered by Mr. Scott of Virginia, code SCOTVA_022.
022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022. 022 Without objection, the amendment shall be considered original text and open to amendment at any point. The amendment in nature of a substitute was distributed electronically in advance. And so I now recognize myself for 5 minutes to explain the amendment in the nature of a substitute. The amendment in nature of a substitute makes small grammatical changes to the bill. I want to reiterate that securing pregnant workers' clear-cut right to reasonable workplace accommodations is a long overdue consideration. These accommodations, such as water and seating, are not complex or costly. For decades, we have provided workers with reasonable accommodations, including workers with disabilities. But without these protections, too many pregnant workers are forced to choose between a healthy pregnancy and their paychecks. At the end of the day, the Pregnant Workers Fairness Act is about ensuring that all pregnant workers across the country can stay safe while on the job. This bill has widespread bipartisan support, and I look forward to passing in the House again this Congress, and urge my colleagues to support the amendment in nature substitute and yield back the balance of my time. Are there others that wish to speak to the amendment in nature of a substitute? The
Chairman.
Gentleman from Idaho, Mr. Fulcher.
Thank you, Mr. Chairman. First of all, thank you for that. And committee Republicans have long been committed to policies that empower all Americans to achieve success. Discrimination of any kind should not be tolerated. No one should ever be denied an opportunity because of an unlawful discrimination. My fellow Republicans and I support protections in federal law for pregnant workers, and we believe all employers should provide reasonable accommodations, especially since future generations will need to pay for the legislation we passed in the last 90 days. We appreciate the bipartisan negotiations that took place during the last Congress to get this bill to where it is today. It's just one example of how effective this committee can be when we work in a bipartisan manner, collaborating and negotiating in good faith. I'm pleased to see that the changes we negotiated last Congress were incorporated in the legislative text for this Congress. When the bill was introduced last Congress, it did not require a pregnant worker, in order to be eligible for an accommodation, to be able to perform the essential functions of the job with a reasonable accommodation. This is a sensible provision, now included in the bill. A definition of known limitations related to pregnancy, childbirth, or related medical conditions was also initially excluded. The bill now includes such a definition, including a requirement that employees communicate the known limitation to the employer. This provision will help workers and their employers understand their rights and responsibilities. Additionally, the bill as introduced last Congress, appeared to allow employees a unilateral veto over offered accommodations. However, the bill now clarifies that reasonable accommodations will typically be determined through a balanced and interactive dialogue between workers and employers. It also did not include a limitation on applicability to employers with 15 or more employees, as in the case of Title VII of the Civil Rights Act and Title I of the Americans with Disabilities Act. But it now includes the 15 employee threshold. Finally, the bill now includes a provision that if an employer makes a good faith effort to determine a reasonable accommodation through the interactive process with the employee, the employer is not liable for damages. Unfortunately, while successful bipartisan negotiations from the 116th Congress have improved the bill, one major issue remains. The legislation we will consider could result in religious organizations being denied protections they receive under the law. There's a longstanding provision from the Civil Rights Act that protects religious organizations from being forced to make employment decisions that conflict with their faith. As you know, the First Amendment guarantees all Americans a freedom of religion. And for more than 240 years, Supreme Court decisions and laws written by Congress have maintained strong protections for religious liberty. Excluding such a provision in this bill would lead to confusion and potentially a constitutional challenge. We should be mindful to protect religious liberty and to maintain this kind of protection like those found in other similar laws. Fortunately, Ranking Member Fox will offer an amendment to address this critical inadequacy in an otherwise commendable bill. I ask my committee Democrat colleagues to continue down the path of bipartisanship and collaboration on this legislation and support Representative Fox's common sense amendment. Thank you, Mr. Chairman. I'll yield back.
Thank you. Does anyone else seek recognition on the amendment? The first I have is a gentlelady from Georgia, Ms. McBath.
Thank you, Mr. Chairman. I move to strike the last word.
Young ladies recognized for 5 minutes.
Thank you. Like many women in America, my story includes a struggle to actually get pregnant. And when my husband and I finally succeeded, it was truly a miracle for me and for my family. And after suffering complications with my pregnancy, my doctor insisted that I stay home from work to protect the health of my child and also myself, because I'd lost several pregnancies prior to my son, Jordan. And though I was really lucky and I was, very blessed to be able to stay at home and rest safely during my pregnancy, this is not the case for every pregnant person, every pregnant woman. There's a woman in my district, Christina. She's a nurse in Georgia, and she requested that due to her pregnancy that she receive additional help lifting patients while she was on the unit, on the floor, and that she also be allowed to use an N95 mask when she was interacting with COVID-19 patients, and also that she be allowed to transfer to another department for the health and safety of her unborn child. And unfortunately, all of her requests were denied. And without the accommodations that she needed to maintain a healthy pregnancy, she was forced to quit her job. And so it's so vitally important that mothers like Christina receive the quality health care that they deserve during their pregnancy without the risk of discrimination. Amidst a global pandemic, which has forced millions of women to leave the workforce or to risk their own health, we should be doing everything that we can to help pregnant workers stay healthy and stay attached to the workforce. And we have the opportunity, as Republicans and Democrats right now, to come together and to pass this bill, which passed with overwhelming bipartisan support in the 116th Congress, to ensure that pregnant women can stay healthy on the job. And the time to do this is just right now. And I'm proud, very, very proud to have been a co-lead of HR 1065, which is the Pregnant Workers Fairness Act. And I stand in support of the Democratic ANS today, which will truly help to protect women and their families, women like Christina, because no mother should ever have to choose between the health of themselves and their child, or a paycheck. And I'm really urging my colleagues to support the Democratic ANS and the underlying bill. The time has come, and I yield back the balance of my time.
Thank you. The gentlelady's time has expired. Does anyone else seek recognition on the amendment nature for substitute? The next I have on my side is gentlelady from North Carolina, Ms. Adams.
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady's recognized.
Thank you, Mr. Chairman. As a mother, as a grandmother, I know pregnancies naturally come with a whole host of concerns and worries. As the co-founder and co-chair of the Black Maternal Health Caucus, I also know that women of color confront additional pregnancy stressors as a result of structural and systemic racism. However, what pregnancy should never come with are fears about not having access to reasonable workplace accommodations or fears of being denied employment opportunities due to pregnancy limitations. I'm glad that my colleagues on both sides of the aisle recognize this, because this bill passed the House in an overwhelmingly bipartisan manner last Congress. And so I hope that my Republican colleagues don't needlessly include poison pills today on this bill. It's already bipartisan, and there's no need to hold it back with something that we know won't have broad-reaching support. It's needless and unfair to pregnant workers who need this legislation to advance. So I'm looking forward to moving this bill out of committee today and sending that same bipartisan message again, this Congress. We need to do that. I support the bill. So ask my colleagues to do the same, and I yield back, Mr. Chairman.
Thank you. Gentlelady's time has expired. Does anyone else seek recognition? The next one on my list on our side is gentlelady from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman. I move to strike the last word and speak in favor of the amendment in the nature of a substitute and the Pregnant Workers Fairness Act.
Gentlelady's recognized for 5 minutes.
Thank you, Mr. Chairman. As a mother and a policymaker, I know how important it is to protect the economic security of pregnant workers and working families. Pregnant workers should not have to choose between a healthy pregnancy and a paycheck, especially when simple accommodations, such as providing seating, water, bathroom breaks, would allow them to stay on the job safely during their pregnancy. Today, women make up nearly half of our workforce. 64% of mothers in the United States are either the sole family breadwinner or a co-breadwinner. Their wages pay for rent, groceries, childcare, healthcare. Yet more than 4 decades after passage of the Pregnancy Discrimination Act, federal law is still not preventing discrimination because it does not require that pregnant workers have access to reasonable workplace accommodations. Pregnant women today continue to suffer workplace discrimination at an alarming rate. A survey from the National Partnership for Women and Families estimates that 250,000 pregnant workers are denied their requests for reasonable workplace accommodations nationally each year. Pregnant workers are in even greater need of reasonable accommodations during the pandemic. According to the Centers for Disease Control and Prevention, pregnant women may be at an increased risk for severe illness from COVID-19. And at the same time, women are being forced out of the labor market at unprecedented rates. My home state of Oregon is helping to lead the way on protections for pregnant workers. The state legislature recently passed a very bipartisan bill to require employers to provide reasonable accommodations to applicants or employees with no limitations related to pregnancy, childbirth, or a related medical condition, unless it would impose an undue hardship. It has helped workers like Megan, an hourly manufacturing worker who was forced to take unpaid leave after her employer denied a reasonable accommodation so she could stay safe on the job during her pregnancy. Pregnant women have welcomed the accommodations, and importantly, the business community has welcomed the certainty. But we need to make sure that all pregnant workers, regardless of where they live, can access the protections they need to stay in the workplace. Last week, I was honored to chair the joint subcommittee hearing on workplace discrimination, and we heard very compelling testimony from witnesses who established that far too many pregnant workers are denied access to reasonable workplace accommodations despite federal law providing for equal treatment on the job. The Bipartisan Pregnant Workers Fairness Act is our opportunity to address pregnancy discrimination in a meaningful way and to protect the health, well-being, and economic security of pregnant and parenting workers and their families. It is a long overdue fix to the inadequate patchwork of protections under existing law. By clarifying the right of pregnant workers to fair treatment in the workplace, pregnant workers will have the accommodations they need without fear of facing discrimination or retaliation. I urge all of my colleagues to support this bipartisan bill, and I yield back the balance of my time.
Thank you. That's all I have so far in speaking to the amendment nature of a substitute. There are no other speakers on the amendment nature substitute. The
Mr. Chairman. Mr. Chairman.
I'm sorry. Yes.
This
gentleman
is
from Idaho.
Yes, I have an amendment at the desk.
Okay, gentleman has an amendment at the desk. The clerk will report the amendment.
Chair,
Wait a minute.
trying to seek recognition to speak in support of the previous amendment before we move on.
Will the gentleman suspend, Mr. Fulcher?
Yes, of course.
Okay, gentlelady from Connecticut, Ms. Hayes.
Thank you. Mr. Chairman, I move to strike the last word.
Gentlelady's recognized for 5 minutes.
I've spoken numerous times in this committee regarding my own experiences with reasonable accommodations during my pregnancy as an educator. I needed a very basic accommodation, more frequent bathroom breaks, which became incredibly burdensome for my school and for myself during my pregnancy. It is alarmingly clear that my experience is not out of the norm, especially for women and women of color, who are more likely to hold inflexible and physically demanding jobs that can present specific challenges for pregnant workers, such as home health aides, food service workers, package handlers, and cleaners. The labor-intensive requirements of these jobs sometimes require a temporary reasonable accommodation so women can remain on the job while protecting the health of themselves and their babies. Like we heard in our hearing last week, These accommodations can be as minor as having a bottle of water nearby, or in my case, getting coverage for my classroom so that I could go to the bathroom more frequently. But all too often, women are told by their employers that they cannot accommodate even the smallest of changes to protect their health and safety. Increased health risks compound the risk posed by these denials for women and women of color. Black women face higher risks of pregnancy-related complications like preterm labor, preeclampsia, and hypertensive disorders. This renders accommodations on the job even more important, and loss of wages and health insurance due to pregnancy discrimination especially challenging. The irony of the assertion that reasonable accommodations like a water bottle or a bathroom break are sitting instead of standing are too burdensome for employers is underscored by the Herculean responsibility borne by so many women through this pandemic. It is only reasonable that we can now expect the same. It is only reasonable that they can now expect the same of their employers. The passage of the Pregnant Workers Fairness Act will ensure that the 85% of women who become mothers during their working lives do not lose their paychecks, their health insurance, or their professional seniority, all because they have chosen to start a family. I enthusiastically encourage my colleagues to support the bill, and I yield back.
Thank you. Gentlelady's time has expired. Gentleman from Idaho has an amendment at the desk. The clerk will report the amendment.
Mr. Chairman, I have amendment to the amendment in the nature of a substitute to HR 1065 offered by Mr. Fulcher, code FOXX_014.
Thank you. The amendment has been distributed electronically. And the gentleman from Idaho is recognized for 5 minutes on behalf of his amendment.
Thank you, Mr. Chairman. Committee Republicans support protections in federal law for pregnant workers and believe employers should provide reasonable accommodations for pregnant workers. I'm supportive of the provisions contained in HR 1065, which I previously outlined. I'm also appreciative of the negotiations that took place in 2019 to improve a previous version of the bill. These modifications are included in the text of HR 1065 and the chairman's amendment in the nature of substitute. Unfortunately, as was the case when this bill was considered last year, there still remains an important outstanding issue which needs to be resolved. The bill should include a narrow but long-standing provision from the Civil Rights Act protecting religious organizations from being forced to make employment decisions that conflict with their faith. This limited provision is already in current law, and it allows religious organizations to make religiously based employment decisions. By not including this long-standing Civil Rights Act provision, HR 1065 could create legal risk for religious organizations. At least 16 states and the District of Columbia in their pregnancy discrimination or pregnancy accommodation laws also include a provision similar to the Civil Rights Act, religious organization protection. By adding a simple reference to HR 1065 to the Civil Rights Act, we can harmonize the bill and current law and ensure that religious organizations receive the same protections they already have had in the Civil Rights Act. My amendment includes the text of HR 1065 in its entirety, with one important addition relating to religious organization protections. My amendment simply incorporates the Civil Rights Act religious organization protection to ensure these organizations are not forced to violate their faith in making employment and accommodation decisions. Thank you, Mr. Chairman. I yield back.
Thank you. Gentleman's time has expired. Does someone seek recognition to speak on the amendment? I have the gentlelady from Pennsylvania, Ms. Weil.
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you. I am opposed to this amendment that would endanger the health and safety of the very people we are here to protect with the Pregnant Workers Fairness Act. We need this bipartisan bill, one supported by the U.S. Chamber of Commerce, because all too often women are forced to choose between their economic security and their health and the health of their babies. It's needed by the women who have asked for accommodations in lifting requirements because their doctors told them they were at high risk of miscarriage or preterm birth. It's needed by the worker in Pennsylvania who was denied a schedule change and fired due to cramping in her uterus that landed her in the ER. This bill is not some new burden on employers. They already must engage in a good faith interactive process over reasonable accommodations under the ADA. But this amendment invites discrimination. It emboldens those who would use religion as a basis to discriminate against people who are pregnant and not married, workers and same-sex couples, women who used IVF to get pregnant, even people with partners of a different faith. Something I want to ensure that we are all clear on is that employers already have other religious exemptions under the law, which would apply to the Pregnant Workers Fairness Act. PWFA already exempts small employers, both religious and secular, who have fewer than 15 employees from its requirements. A religious employer could still make a claim using the RFRA, the Religious Freedom Restoration Act, by asserting that the federal government substantially burdens their religious exercise in a manner that is not narrowly tailored to further a compelling state interest. Some religious employers may be able to use the ministerial exception, which is a constitutionally recognized wholesale exemption from civil rights law as a defense against PWFA. That exception applies to employees who preach and teach the faith and applies to PWFA as it applies to other civil rights laws. So this amendment would frustrate the purpose of a good bill, a bill that is supported by the Chamber of Commerce and by 89% of voters. When pregnant women are denied accommodations, they face health risks, miscarriage, and premature births. This bill, as written, already takes employer concerns and reasonableness of requests into account. I urge my colleagues to reject this amendment and to support the underlying bill. And with that, Mr. Chairman, I yield back.
Thank you. Gentlelady's time has expired. Do others wish to speak to the amendment?
Mr. Chairman.
Gentlelady from North Carolina, Ms. Manning.
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized for 5 minutes to strike the last word.
Mr. Chairman, I rise to speak in opposition to this amendment. Protecting pregnant women should not be a partisan issue. We all benefit, Democrats and Republicans alike, from the ability of pregnant women to protect their health, deliver healthy babies, return to their jobs, and continue to provide value to their employers. With this amendment, my Republican colleague seeks to inject controversy where none should exist. I can't imagine any reason a religious organization should be allowed to discriminate against pregnant women and put their health at risk based on the underlying principles of their faith. In fact, I find the suggestion that any religious institution would want to discriminate against pregnant women to be offensive and contrary to all the religions of which I am aware. This bill provides for reasonable accommodations. It does not require employers to make accommodations that are unreasonable or destructive to the employer's business. That should be a standard that all employers can meet and should want to meet. In fact, I would think that religious institutions would aim for a higher standard of care for the vulnerable, rather than seeking an exemption from accommodating those they should seek to protect. Moreover, religious employers are already protected by the PWFA, as stated so eloquently by Representative Wild. I fear that this amendment opens the door to allowing employers to impose their personal opinions about whether a particular woman's pregnancy is desired or appropriate, and to discriminate against those women whose pregnancies they may not find desirable. This is exactly the type of discrimination we should be prohibiting, whether it is religious-based, race-based, ethnically based, or otherwise. I strongly oppose the use of religion as a means of discrimination and urge my colleagues to vote against this amendment. I yield back.
Thank you. Gentlelady's time has expired. Does anyone else seek recognition? Anyone on the Republican side? I don't see anybody. Gentlelady from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman. I move to strike the last word and speak in opposition to this amendment.
Gentlelady's recognized for 5 minutes.
Thank you, Mr. Chairman. I want to start by aligning myself with the comments made by my colleague, Representative Wild and Representative Manning. A religious exemption in the Pregnant Workers Fairness Act will open the door to discrimination and harm the very people we're trying to protect, pregnant workers who need modest accommodations to prevent complications and maintain a healthy pregnancy. Protecting pregnant workers is not and should not be a partisan issue. This amendment simply injects controversy where there is none. The Pregnant Workers Fairness Act is supported by a broad coalition and reflects carefully balanced agreements. This provision will undermine support for the bill from key constituencies, including groups representing pregnant workers and civil rights organizations. Religious employers are already afforded significant protection under the current legal framework by trying to incorporate a religious exemption. The minority is losing sight of what the committee is trying to accomplish, making sure that pregnant workers can safely continue working. We do not need to open the door to discrimination against pregnant women in the name of religion, and I urge my colleagues to oppose this amendment, and I yield back the balance of my time.
Thank you. Generally, time has expired. Does anyone else seek recognition? If not, I recognize myself for 5 minutes on the amendment. Just to make a couple of technical clarifications, the bill does not in any way amend or change the religious exemption for religious employers under Title VII of the Civil Rights Act. That exemption allows religious institutions to prefer people of their own faith in employment, nor does it amend the Americans with Disabilities Act of 1990 or otherwise limit the existing religious exemptions contained in that statute. These laws remain unaffected by the legislation. The Pregnant Workers Fairness Act is standalone legislation. The minority points to the state pregnancy accommodation laws as an example that Congress should follow. Congressional Research Service analyzed those laws and found that in nearly every case, those state laws, religious exemptions, predated a subsequent enactment of the Pregnant Worker Accommodations Law and were not expressly added as part of the state pregnancy accommodation laws. Second, the ministerial exception recognized by the Supreme Court that applies to employees whose jobs are to preach and teach the faith would apply to this bill, and does not, and it does as it does to all other anti-discrimination laws. That exemption is not affected by this legislation. Third, the Pregnant Workers Fairness Act is not exempt from the application of the Religious Freedom Restoration Act. Finally, the bill has an exemption for small employers, both religious and secular, who have fewer than 15 employees. So despite all these existing religious exemptions, we're debating what I feel is an unnecessary amendment that would further permit employers to deny accommodations for pregnancy-related conditions if the employer is religious. The repercussions of adding the religious exemption to this vital bill could be devastating for pregnant workers. For example, religious employers who do not believe in the use of in vitro fertilization could deny reasonable accommodations to women who need medical assistance to successfully build a family. It could also enable religious employers to deny reasonable accommodations to women who are pregnant and divorced, or pregnant out of wedlock, or pregnant in a same-sex relationship. The Pregnant Workers Fairness Act reflects a carefully crafted agreement and is supported by a broad coalition of over 200 organizations, from the business community to women's rights groups, labor organizations, civil rights groups, and a wide array of faith-based organizations. Some of these groups have indicated in no uncertain terms that this amendment is a poison pill, and that if adopted, they will no longer support the legislation. If adopted, this amendment will force women to choose between their health and the health of their pregnancy and paying their bills, keeping a roof over their head, putting food on their table, and affording their prenatal care. So I strongly urge a no vote on the amendment and to the amendment in nature of a substitute, and yield back the balance of my time. Does anyone else seek recognition? If not, the question is on the reporting of the bill, and that will be rolled until the end. The next order of business is the HR 1195, the Workplace Violence Prevention for Healthcare and Social Service Workers Act. The bill was circulated in advance electronically, and the clerk will designate the bill.
Mr. Chairman, I have HR 1195 to direct the Secretary of Labor to issue an occupational safety and health standard that requires covered employers within the healthcare and social services industries to develop and implement a comprehensive workplace violence prevention plan and for other purposes.
Without objection, the first reading of the bill is dispensed with. And second reading, without objection, the bill will be considered as read and open for amendment at any point. Any amendment offered shall be considered as read. I now recognize the gentleman from Connecticut, Mr. Courtney, for the purpose of an amendment.
Thank you, Mr. Chairman. Mr. Chairman, I have an amendment in the nature of a substitute at the desk.
The clerk will report the amendment.
Amendment in the nature of a substitute to HR 1195 offered by Mr. Courtney of Connecticut, identifier WPV_ANS.
Without objection, the amendment shall be considered original text and open to amendment at any point. The amendment in the nature of substitute was distributed electronically in advance, and I now recognize the gentleman from Connecticut for 5 minutes to explain the amendment in the nature of a substitute.
Thank you, Chairman Scott, for taking action on this bill early in the 117th Congress. As you recall, this legislation passed the House of Representatives in 2019 with 251 votes, a solid bipartisan margin. This was after the committee held a legislative hearing to discuss the issue with social workers, healthcare workers, and subject matter experts, as well as a markup to advance the bill. Last week, we had a similar hearing at the Workplace Protection Subcommittee under Chairwoman Adams, where again, we received an update regarding this issue, and sadly, the violence that's occurring in healthcare institutions just continues unabated. The amendment in the nature of substitute will make three main changes to HR 1195. Number one, it strikes the findings section. Number two, it provides that Executive Order 12866 involving regulatory review does not apply to the interim final standard, and clarifies the criteria in the final standard to ensure that while it must be no less protective than a state OSHA plan for workplace violence, the standard must still be deemed by the Secretary of Labor to be feasible. Mr. Chairman, this committee has been tracking the issue of violence against healthcare workers for nearly 8 years. We're now in our third presidential administration, and still this problem remains inadequately addressed despite widespread agreement that a standard is needed and that a standard actually exists at OSHA, which is, however, only a voluntary guidance. Anyone who's worked in a hospital or as a psychiatric aide, a social worker, or an emergency responder knows how pervasive this problem is and how it affects the ability to do their jobs. The primary source of the violence comes in the form of assaults: kicking, hitting, spitting, verbal threats from patients, residents, and clients, or those who accompany them. In addition, the often serious physical injuries, it affects workers' sense of safety at work, contributes to burnout, turnover, and high workers' compensation costs and stress. This past year, healthcare workers have received universal praise for the work that they've done in dangerous conditions to care for our communities during the pandemic. But long after COVID-19 is controlled, these workers will continue to face dangers of preventable violence at work unless this bill is enacted. In 2013, this committee requested a report from GAO to finally determine how pervasive this violence is and what strategies are at our disposal to reverse the trend. This report found that workers in healthcare facilities experience substantially higher rates of non-fatal injury due to violence in the workplace compared to workers overall. So it's no wonder that at this point, this bill has been endorsed by just a whole host of healthcare professional associations like the American College of Emergency Physicians, American Nurses Association, the American Psychiatric Association, the American Psychiatric Nurses Association, the Emergency Room Nurses Association, and the National Association of EMTs, Emergency Medical Technicians, who, when they're out on these calls, in many cases are feeling the full brunt of the turmoil that's out there, a lot of it driven by the opioid addiction and behavioral health problems that sadly are growing. It also has been endorsed by a whole host of labor unions who represent healthcare workers that have brought this issue to our committee a number of years ago, as well as subject matter experts and educational institutions. According to the Bureau of Labor Statistics, healthcare and social service workers are nearly 5 times more likely to suffer injury from workplace violence than workers in other settings. Up to 30% of hospital workers report being assaulted at work, and nearly 50% of emergency room physicians have been physically assaulted at work. These events should not be part of the job. They should not be a daily, weekly, or monthly occurrence. But unfortunately, the data shows otherwise. Between 2006 and 2019, there was a nearly 60% increase in violent incidents that occurred in healthcare and social service workplaces that resulted in employees being away from work. Since 1996, OSHA has published voluntary guidelines that recommend common sense preventive measures that employers can take to reduce the risk and severity of violent incidents, and they were updated in 2015. And again, it includes training, it includes better systems of communication for workers who are dealing with high-risk patients. It sometimes just deals with very simple arrangements to sort of create more space to accommodate, again, more eyes on the patient so that people are safer. And we know that hospitals that have actually implemented these common sense rules have shown a dramatic decrease in violence that, again, we know will work if it's implemented as an enforceable standard. And that's what this bill does. It basically takes a set of guidelines that we know works, that's the cake is baked, and make sure that it's applicable through an enforceable standard in a reasonable time period. This issue has festered long enough, and we need to move forward and get this done once and for all. I yield back.
Thank you. Gentleman's time is expired. Does anyone wish to speak to the amendment in nature of a substitute on the Republican side?
Fred Keller from Pennsylvania.
Gentleman from Pennsylvania is recognized for 5 minutes to speak on the amendment.
Thank you. We all agree that violence in any form is wrong. The data shows that our healthcare and social service workers are the most susceptible to occupational injuries by workplace violence. It is our duty to work together and find a solution to this serious problem. Democrats will tell you that HR 1195 is the answer. But unfortunately, a rushed one-size-fits-all initiative that cuts corners and bypasses necessary regulatory analysis while ignoring the data, recommendations, and experiences of valuable stakeholders will not solve anything. This strategy would burden struggling rural hospitals during a time when so many in Pennsylvania and around the country are at risk of closure. The daily risks that our healthcare and social service workers face in the workplace are the utmost concern and deserve thorough consideration. The Occupational Safety and Health Administration, OSHA, recognizes these risks and is currently working on a rule to address this important issue. This rulemaking process must account for the important views of impacted stakeholders and ensure effective, long-lasting policy. From major hospitals to rural clinics, all voices are needed to make an informed decision that provides adequate solutions. HR 1195 will circumvent many of the important regulatory laws and executive orders that guide the OSHA rulemaking process. American workers deserve more than rushed legislation that forces OSHA to issue a prejudged solution to a complex problem. Through the General Duty Clause of the OSHA Act, which requires employers to take affirmative steps to protect their employees and provide a workplace that is free from recognized hazards, OSHA has issued citations against employers relating to workplace violence incidents. And most hospitals across the country have established organization-wide initiatives to address workplace violence. Rushing to mandate an ill-conceived response to this problem will not only result in an insufficient solution, it will also be damaging. The healthcare industry is currently handling the pandemic admirably, but will likely face sweeping and burdensome OSHA regulations from the Biden administration on COVID-19 in the near future. On top of these inflexible rules, the Congressional Budget Office previously estimated that compliance costs would be at least $2.7 billion for private facilities and $100 million for public facilities over the first 2 years of the rule prescribed by this legislation, should it become in effect. In the long term, combined compliance costs for the private and public sectors would run at least $135 billion annually, and substantial personnel and capital costs would result from this bill's requirements. This strain on the industry will be felt especially by medical facilities in rural areas and other vulnerable communities with scarce resources who have been operating on the front lines of the pandemic. We need to make sure that they have every tool at their disposal to continue doing the great work they do in our communities every day. Rather than issuing a rushed perspective and uninformed standard without appropriate public input and analysis, I join my fellow Republicans on this committee in calling for a reasonable, workable, and thorough response to the serious issue. We owe that much to our frontline healthcare professionals as they fight COVID-19. Overbearing regulations burden workers and stifle the economy. Preventing workplace violence in healthcare and social service settings is crucial, and we should get this done by allowing Osha to issue a standard through the normal rulemaking process, which brings all experts and all parties to the table. Short-circuiting the process and rushing to a conclusion eliminates valuable technical and scientific input and will lead to unintended consequences, which could have a detrimental impact on improving workplace safety outcomes. Thank you, and I yield back.
Thank you. Gentleman's time has expired. Next, I'll recognize gentlelady from North Carolina, Ms. Adams.
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman's recognized 5 minutes.
Thank you. All workers deserve to be treated with dignity and respect. Our labor laws must uphold that principle. Unfortunately, our healthcare and social service workers face disproportionately high rates of violence on the job. So we've got to do something to address that. And Mr. Courtney's bill does address that, and I support it. This critical piece of legislation requires that OSHA issue a workplace violence prevention standard for employers in these sectors in order to actively prevent, address, and track workplace violence incidents. So we rely heavily on healthcare and social service workers, and that truth has been even clearer during this pandemic. So we've got to ensure their well-being just as they work to ensure our well-being every day. I yield back, and I support this substitute and this amendment by Mr. Courtney. This is a great bill. Let's vote for it and get it out. Thank you, Mr. Chairman. I yield back.
Thank you. Gentlelady's time has expired. The gentleman from North Carolina, Mr. Cawthorn, seek recognition.
Yes, sir.
Recognized 5 minutes to strike the last word.
Thank you, Chairman Scott and Ranking Member Fox. I believe that HR 1195 is poorly timed and will result in significant unintended consequences. This bill would significantly strain healthcare facilities, especially the ones in my district in the mountains, Western North Carolina. This bill would add another significant challenge to their operational effectiveness. HR 1195 is a clear example of a rushed, prescriptive, and uninformed standard. We need to have more public input. We need to let more stakeholders weigh in. We should be measured and sober as we tackle these issues. However, Democrats refuse to allow that process to take place. We need a workable and thorough response to this serious issue, not a rushed, politicized talking point that is intellectually lazy. We must keep in mind that OSHA is already in the process of writing a workplace violence regulation and has also taken important steps to independently analyze this issue. We ought to let OSHA determine what type of policy best protects workers and provides employers with the necessary support and flexibility to ensure employees are safe on the job. Now, let me be clear, workplace violence is a critical hazard in the healthcare and social services industries. That should be addressed by OSHA, but I do believe that HR 1195 is the wrong approach. And with that, I yield back.
Thank you. Gentleman's time has expired. Gentleman from California, Mr. Chicano.
Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
The issue of workplace violence in healthcare settings has long been something that we've needed to address, and I endorse and support the legislation offered by my colleague, Mr. Courtney. I urge all of my colleagues to support it. We've been needing this legislation for quite some time, and I hope that we are able to come to some agreement and move this legislation on a bipartisan basis through the House. And I yield back.
Gentleman's time has expired. Does anyone else seek recognition? Miss Gentleman lady from Pennsylvania, Ms. Wild.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized for 5 minutes.
Thank you. I speak today in support of the Workplace Violence Prevention for Healthcare and Social Service Workers Act, a bill that I am proud to co-sponsor. My constituents in the 7th District of Pennsylvania have the luxury of world-class health networks and care right here in our communities, institutions that we hold in very high regard. And those health networks are so respected and valued because of our healthcare workers and their commitment to patients. It's the nurses who are trained to look for the signs of a patient experiencing domestic violence. It's the primary care physicians screening their patients for substance misuse and unmet behavioral health care needs. It's our OBGYNs who work the night shift to keep top quality maternity care available to all women. And for the past year, it's the emergency room and infectious disease nurses, doctors, and frontline workers who have been working nonstop to care for those afflicted by COVID-19 right here in the Lehigh Valley. Healthcare workers come from different backgrounds and have an array of specialties, but they all share the same goal of a positive outcome for each patient. They deserve to devote their full attention to this goal and to their patients, and not to be distracted by the fear of workplace violence. But the sad reality is that workplace violence is prevalent in the healthcare industry. Studies have found that 19 to 30% of hospital workers have been assaulted at work. That problem has worsened over the last 10 years, while we are also seeing a shortage of registered nurses and physicians, a shortage that is only expected to worsen as the baby boomer generation ages. Requiring employers to develop minimum violence prevention plans, train employees on an annual basis, and report and track violent incidents will reduce workplace violence. I also want to take a minute to point out that the time and resources spent developing these plans is a good investment for institutions. Hospitals that have enacted similar measures saw a reduction in violence-related injuries by 55% over 3 years. That's lower costs associated with worker injuries, less employee time lost while recovering, and lower employee turnover for the hospitals. According to an American Hospital Association-sponsored study, hospitals are currently spending $234.2 million for staff turnover due to workplace violence and $90.7 million in disability and absentee costs. A safer workplace for our healthcare workers is a good investment for hospitals, for workers, and for patients. This bill is the necessary and evidence-based step we must take to protect those who care for all of us. I urge my colleagues to join me in supporting this vital bipartisan bill to protect our frontline health and social care workers. Thank you, Mr. Chairman. I yield back.
Thank you, gentlelady's time has expired. Does anyone else seek recognition? Next on my list is the gentleman from Michigan, Mr. Levin.
Thank you so much, Mr. Chairman. I move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, all throughout this horrible pandemic, We have praised the dedication and sacrifice of our nation's caregivers. They do the vital work of taking care of the most vulnerable among us. But our appreciation must not be mere lip service. We need to act to ensure that nurses and social workers are safe in their workplaces. The people who work as caregivers do so out of a sense of service, knowing that these jobs are often very difficult. But no worker, regardless of their job, should face violence in their workplace. Public health and social workers deserve a sense of security when they go to work. Unfortunately, OSHA does not have the basic tools to protect healthcare and social service workers. The proposal we're considering is a simple and common sense solution that fixes this issue in a systematic and thoughtful way. It empowers OSHA to develop a standard to implement a workplace violence prevention plan tailored to the different caregiving sectors. I salute Mr. Courtney for this excellent bill. I'm proud to support it because safety in the workplace is essential and non-negotiable. I found out about this issue starting way back in 1983 when I started helping nursing home workers who were forming unions with the Service Employees Union. I was shocked to find out about some of the violence that these workers faced, often with no recourse, nowhere to turn. And it's something we simply have to deal with. Lord knows in this pandemic. We've got to advance this bill because our praise for workers cannot be just words, lest they seem hollow. We must actually act to protect workers in their workplaces. Thank you, Mr. Chairman, and I yield back.
Thank you. Anyone else seek recognition on the Republican side? If not, gentlelady from Michigan, Ms. Stevens.
Thank you, Mr. Chair. I'm moved to strike the last word.
Gentlelady's recognized for 5 minutes.
I'm a very proud co-sponsor of the Workplace Violence Prevention for Healthcare and Social Service Workers Act, HR 1155. This bill was put together through incredible intellectual rigor, attention, respect, and reverence for the law and the gaps in our laws that have brought us to this place, and recognizing the compilation of thousands and thousands of working people, the long list of organizations that stand behind this legislation. We know we need to get this done, and the bill couldn't be coming at a more critical time. You talk to our frontline workers, you talk to those who work in our hospitals, you see the instance of the event just the other day in Iowa, where we had, and we just learned this yesterday, that a correctional officer and a nurse were both killed, life lost by a horrific attack from an inmate. Violence in the workplace needs to be elevated. Both would have been covered in Iowa under this bill, under this legislation. So this very thoughtful, very brilliant legislation crafted by the remarkable Congressman Joe Courtney from Connecticut, who you get the chance to work with Mr. Courtney, and you're moving in the right direction, and it's just brilliant to watch him work. This bill is going to direct OSHA to issue a workplace violence prevention standard. The standards of OSHA. Haven't we talked about this on this committee a lot in the last year? The standard including an interim final standard that would protect employees from workplace violence within 1 year while OSHA works on that final standard. This would also allow the final rulemaking process required under the Administrative Procedures Act to take place before the final standard is issued. Some of you may recall that last Congress, I offered an amendment to provide a 30-day comment period before the interim final standard is issued. And I'm deeply honored and greatly pleased that that has been included in the bill this year, because we're going to pass it through committee and we're going to bring it to the floor, just as Mr. Courtney reminded us. So we see and feel the urgency. We know this in our communities because we are connected. Our hospitals, testified on this, the doctors, the nurses, and the individuals who sometimes experience this in unbelievable ways. And certainly we know that this is all the more relevant as this nation reconciles and deals with once and for all, God willing, our gun safety legislation that we passed the other week in the House. We've got to get this done. It's happening out in Colorado, happened in Atlanta. We need to get this bill done. So we're glad that the comment period is included. We're glad that the nitty gritty is in here. Those of us in Michigan are standing by this with our AFL-CIO and all the hardworking men and women of this country to get this done. I urge all my colleagues to vote yes, and I salute Mr. Courtney yet again for all his great work. Thank you.
Thank you. The gentlelady from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman. I move to strike the last word so I can speak in favor of the Workplace Violence Prevention for Healthcare and Social Service Workers Act.
Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. A few years ago, 2 workers in Oregon were tragically wounded in a worksite stabbing at an organization that provides essential support services to youth who are facing addiction, homelessness, and behavioral health issues. I remember it well because my son worked there at the time. And as a parent and a policymaker, it was terrifying. Following the incident, Oregon AFSCME members organized to improve the difficult working conditions that were compromising the quality of services for vulnerable clients and safety of the employees. Workers in Oregon and healthcare and social service workers across the country need evidence-based workplace violence prevention plans that are tailored to the needs of the populations they serve. But the Occupational Safety and Health Administration, OSHA, does not require employers to implement workplace violence prevention programs, which perpetuates the unacceptably high risk of injury for many workers. Fortunately, several states, including my home state of Oregon, have taken steps to better protect healthcare workers. The Oregon State Legislature recently passed a bill to require healthcare employers to conduct comprehensive safety evaluations using a state or nationally recognized workplace violence prevention toolkit. In our state, this will also require employers to document when, where, and how assaults occur, with the intent to develop new systems to prevent similar incidents in the future. These are important steps, but comprehensive and enforceable standards must be established at the federal level. And that is why I'm an original co-sponsor of Congressman Courtney's Workplace Violence Prevention for Healthcare and Social Service Workers Act. And I thank Representative Courtney for his work on this important issue. I want to note, Mr. Chairman, that I strongly disagree with a comment that was made by a member of this committee alleging without merit that this bill is somehow intellectually lazy. Far from it. Mr. Courtney is hardworking and intellectual, and he does not deserve that unfounded criticism. The pandemic has upended lives and presented significant health and financial challenges for our families, neighbors, and communities. It's also exposed us to the harsh workplace conditions that nurses, doctors, social workers, behavioral health workers, and other healthcare workers have endured to keep our communities going. Healthcare and social service workers help care for our families, friends, loved ones, and today we have a chance to support their well-being and safety in the workplace. I urge all of my colleagues to support this important bill, and I yield back the balance of my time.
Thank you. Gentlelady's time has expired. Does anyone else seek recognition on the Republican side? If not, gentlelady from Connecticut, Ms. Hayes.
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady is recognized for 5 minutes.
I yield the balance of my time to Mr. Courtney, my colleague from Connecticut.
I want to thank the gentlelady from Connecticut, my good friend and neighbor. And very quickly, first of all, I just want to, thank the minority members, the Republican Party members who have clearly recognized that we're not talking about some imaginary problem here. It is real and it's happening in real time, literally almost every single day. And but I would like to address the comments made by the gentleman from Pennsylvania who talked about the cost impact of regulation regarding this bill. Again, the numbers that he cited are being used by some advocacy groups out there. I would just note that the cost per year that he quoted actually was from a CBO report that came from an earlier draft of the legislation. In the shaping of the bill last Congress, we made some adjustments to the legislation to just clarify that the scope of the bill does not extend to every single healthcare office or institution, so that an office of a physician, dentist, podiatrist, or other healthcare practitioner who's not physically located within a covered facility this does not apply to whatsoever at all. And as a result of that language, which is in the base bill that we're considering here today, CBO actually revised their score. And I would ask Mr. Chairman to have that report, which is dated November 19th, 2019, admitted for the record.
Without objection.
And what it shows is that, in fact, for the first 2 years of the legislation, or after a rule is actually adopted, it will take 42 months, by the way. We're allowing the OSHA to take 42 months, which is about 3.5 years. This is on top of 8 years of research that's been done on the bill. That it shows that, in fact, the entire private healthcare sector, including rural hospitals and everybody else across the country, would be $1.8 billion in the first 2 years that the final rule is in effect, and $750 million annually thereafter. If you do the math in terms of the number of facilities and divide that, into the figure that I just cited, we're talking at about $9,000 per facility per year. And so, that's what we're talking about. And by the way, CBO acknowledged that they did not actually include absenteeism, the cost of absenteeism that would be reduced if this workplace standard was put into effect. So I actually think they underestimated the savings that having a prevention standard, which is about preventing injury and cost that's associated with workers' comp claims, and also cost in terms of lost time at work. So again, I'm glad he brought up that figure, because it is still rattling around out there, but it's out of date. It is irrelevant to the bill that we're considering, and the cost is much smaller. And when people ask about, well, why is an interim standard being adopted? And again, I want to thank Congresswoman Stevens for her amendment into the bill, which guarantees there will be public comment. This is not something that's going to get railroaded through. Stakeholders are going to have an opportunity to weigh in terms of any draft that's included in the standard. But the fact is that what we have seen with OSHA, sadly, over and over again, is that the delays that take place in the rulemaking is just totally unacceptable. So let's talk real terms. When the Trump administration took over in January 2017, the prior administration had literally just received the GAO report. They had started the rulemaking process. The new administration took office in 2017. They removed this issue from the rulemaking process and put it into their long-term agenda, which is basically like going into purgatory. 2 years later, they finally said, well, we're gonna schedule a small business review. It's a SBREFRA panel, which is the first baby step in the OSHA rulemaking process for January 2019. That got delayed to March 2019. The March 2019 got delayed to October 2019. The October 2019 got delayed to January 2020. And then the January 2020 was delayed until December 2020. So guess what? Clock ran out. We had an entire 4-year term in the last administration where absolutely nothing was done. And as Congresswoman Stevens points out, in real time, people are getting hurt out there. She talked about the incident in Iowa. In early February in Minnesota, a disgruntled patient showed up in Buffalo Minnesota at a healthcare facility and shot a healthcare worker dead and critically wounded 3 others. And those are the most extreme examples, but you talk to anybody who is in the business, they will tell you that the kicking, hitting, spitting is happening in real time. And we can't just tell people to shake it off anymore. We need to put into place real standards that have been around since 1995 so that we reduce this epidemic. I yield back.
All right, gentlemen's time. Whoops, gentleman's time has expired. Does anyone else seek recognition? If not, are there amendments to the amendment in nature of a substitute? Does anyone have an amendment? Gentleman from Michigan, Mr. Wahlberg.
Thank you, Mr. Chairman. Appreciate the opportunity to bring an amendment in nature of a substitute. Healthcare and social service workers face real risks of workplace violence. None of us.
Just a minute. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to HR 1195 offered by Mr. Wahlberg of Michigan, code WALBER_017.
Gentleman's recognized for 5 minutes on behalf of this amendment.
Thank you, Mr. Chairman. Healthcare and social service workers face real risks of workplace violence. None of us dispute that. All of us are concerned with that. The numbers show that these workers are at a higher risk for occupational injuries from the workplace violence of any industry, and this issue demands our attention and thoughtful consideration. Unfortunately, HR 1195, the Democrats' proposed solution, is excessively prescriptive and heavy-handed. It takes the wrong approach, prejudging and imposing a rushed regulation without allowing for necessary stakeholder input. That's why I'm proud to offer the Republican substitute amendment. My amendment ensures that in issuing a workplace violence standard, OSHA will still follow proper rulemaking procedures and be responsible to the public comments received during the rulemaking process. It also calls on OSHA to convene the already planned Small Business Regulatory Enforcement Fairness Act panel before proceeding with the rulemaking process to allow small businesses the opportunity to comment on regulatory text. Incorporating the insights and experiences of all stakeholders will allow OSHA to craft a rule that meets the needs of all workers and is informed by appropriate feedback and analysis. This amendment would also require OSHA to conduct an educational campaign on workplace violence prevention in healthcare and social service industries. This initiative would target the regulated community and raise awareness of the issue while also increasing compliance with the eventual final rule. Further, this amendment recognizes the reality that the healthcare industry is in the midst of responding to a major public health crisis and has rightly prioritized significant resources for responding to the COVID-19 pandemic. As such, my amendment removes the problematic requirement that OSHA issue an interim final standard on workplace violence within 1 year, which is ill-timed considering the expected imposition of additional COVID-19 regulatory mandates from the Biden OSHA in the near future. This common sense amendment acknowledges and supports the work already underway at OSHA so that the agency can implement an effective solution to address workplace violence. As it stands now, HR 1195 is the wrong approach to address this critical problem and will lead to a poorly conceived and rushed regulation that is lacking in valuable public comment and careful analysis. I hope we can all seriously consider this substitute proposal, which is a sensible solution and affirms our bipartisan desire to see OSHA continue with this important rulemaking while also removing damaging provisions in HR 1195. Preventing workplace violence in healthcare and social service settings is crucial, and we should allow OSHA to develop a standard that results from the rigorous and proven rulemaking process, ensuring that experts and stakeholders have a seat at the table. I ask my colleagues to support this substitute amendment so we can take real, meaningful steps toward addressing the critical issue of workplace violence in the healthcare and social service industries. Mr. Chairman, I yield back.
Thank you. I recognize, gentleman's time has expired. I recognize myself for 5 minutes to speak against the amendment. Just and also in general about the legislation. First of all, we know that these plans work. They've been studied. Some of them just involve training and changes of procedures. But if you plan out how workers are to interact with patients, and it can make quite a difference. The compliance costs have been mentioned, but we have to also look at the savings in terms of healthcare costs, worker compensation, lost time at work, and other offsets. So it's there's significant savings in doing this right before you get to the fact of saving injuries and saving misery. We know this bill is timely. Several have mentioned just yesterday, 2 healthcare workers in Iowa lost their lives. We're not sure exactly what could have been done to prevent it, but it obviously points out that the issue needs to be addressed. And we've heard comments about this being rushed. I would just point out that in 2013, the committee at Mr. Courtney's request and at the urging of unions representing healthcare workers, asked the GAO to evaluate the gravity of workplace violence. And 3 years later, they issued a detailed report, 2016, found that healthcare workers employed in inpatient facilities such as hospitals and residential care experience workplace violence-related injuries from 5 to 12 times higher than the rate for private sector workers overall. And for those working in state residential care facilities, the rate of non-fatal violence incidents was 88 times higher than private sector workers overall. And the GAO recommended that OSHA assess whether relying on its voluntary workplace violence prevention guidelines and enforcement under the general duty clause was sufficient, and it called on OSHA to determine whether enforceable standards may be needed. In 2016, OSHA placed the development of a workplace violence prevention rule on its regulatory agenda. But later in 2016, OSHA followed up by issuing a request for information. But between January 2017 and January 2021, there was actually zero forward action on the standard taken by OSHA. And so when you talk about this being rushed, it again gives, when the bill is passed, OSHA will have an additional year to come up with an interim standard, and then 42 months after that to come up with a final standard. People need this protection now, and that's why the bill is necessary. I've been involved in other OSHA regulations, and they just take an excruciating length of time to come up with a final standard, and a year for an interim and 42 months for a final rule is just an indication. The fact that we have to pass legislation to get it that quickly just gives you an indication of how broken the process is. So I'd hope we would defeat the amendment and then pass the bill. Are there others that seek recognition?
Mr. Chairman.
Just a minute. Gentleman from Michigan, Mr. Levin.
Yeah, thanks, Mr. Chairman. I move to strike the last word. And
5 minutes to strike the last word.
Thank you. So I want to start by speaking specifically, Mr. Chairman, about this idea of having an interim standard and an interim standard. And, you know, I think it is clearly well justified in this circumstance. First of all, we need to protect employees from workplace violence within a year, as this does, while OSHA works on the final standard. My colleagues have given eloquent testimony for the need for that immediate protection. Secondly, the HR 1195 allows the full rulemaking process under OSHA and the Administrative Procedures Act to take place before any final standard is issued. And the IFS would only be in effect temporarily while that process goes forward, and it would still authorize the 30-day comment period. And I want to credit my colleague, Representative Stevens, for this. During the markup on this bill in the 116th Congress, she offered an amendment to provide this 30-day comment period. So we even have that level of process for this interim fix. And so there will be public input. And I think that's really important to note. That the Department of Labor has already received extensive input to inform an interim final standard since it had issued a request for information in 2016. And OSHA has decades of experience of working with and updating its guidelines for preventing violence for healthcare and social service workers, most recently in 2015. The last 4 years have seen nothing but inaction, and it proves why this bill and the interim final standard are so necessary. And I just want to add to your words about why we can't wait. OSHA standards have taken so long to finalize that we both need an interim final rule and a quicker timeline. Beryllium took 18 years. Crystalline silica took 19 years. Confined spaces in construction took 22 years. Walking on working surfaces took 14 years. We do not have that amount of time to protect workers. We need this interim final standard, and we need a quicker timeline than all of that to get to a final standard. Mr. Courtney has studied this in great detail, come up with a super reasonable proposal. We need to pass this today, Mr. Chairman, and protect the workers of this country. And with that, I yield back.
Thank you. Gentleman's time has expired. Gentlelady from North Carolina, did you seek recognition?
Yes, sir. Yes, Mr. Chairman. Thank you, Mr. Chairman. The Republican amendment undermines the critical violent incident law that's required in this legislation. HR 1195 requires the employer to send to OSHA annual summaries of the frequency, the quantity, and the severity of workplace violence, including incident response and post-incident investigation. This information is important for OSHA to target compliance assistance and enforcement activity, to track trends and evaluate the effectiveness of the standard. It is not a burdensome requirement. The bill already requires the preparation of the summary in a template prepared by the secretary. There's no additional burden to employers in providing this information to the secretary. I just want to add to Mr. Levin and say how much I appreciate and support Mr. Courtney's hard work on this legislation, and I would support it and would urge my colleagues to support the legislation and to vote against this amendment. And I yield back, Mr. Chairman.
Gentlelady's time has expired. Does anyone else seek recognition? Gentleman from Connecticut, Mr. Courtney.
Thank you, Mr. Chairman. And first of all, I want to thank all the members of the committee that actually have also been very much engaged in this bill for a number of years, including some of my Republican colleagues. Again, Tim Walberg and I served on the subcommittee years ago, and I have a lot of respect for him. And but I would just say that when we debated this in 2019, one of your colleagues and my good friend Bradley Byrne was ranking member on the subcommittee, and really I think very passionately and sincerely made the case for letting the rulemaking process just sort of continue under its regular administrative processes. But he at the time was relying on his own sort of conversations over at the Department of Labor that they actually were going to move on getting a standard in place. And sadly, as I recited a few moments ago, all we saw was just one postponement after another, one delay after and under, which sadly is par for the course at OSHA. I mean, it is a broken rulemaking process. Frankly, I think we should be looking at a reform. And at the subcommittee hearing that we just had with Chairwoman Adams, the Republican witness actually said that for employers, the slowness of OSHA is a problem, because the technology of work changes all the time, and the slowness of OSHA to keep up with that is actually hurting the employer community in this country, as well as the employee side of the equation. So, the interim standard that's included in this bill, there is very sound precedent for moving in that direction. In the past, Congress did that with the Superfund, people who work around Superfund sites. They did it in terms of another pandemic, which was the bloodborne pathogen of AIDS, where again, an interim final standard, and this was under the Bush administration, was put into place so that, all the gloves that you see in hospitals today and the disposable needles, I mean, all that is the result of OSHA rules that were put into place using an interim standard, because again, with the severity of the problem for healthcare workers getting infected with AIDS, the system had to move faster than the normal rulemaking process. And that's really exactly the same precedent that we're using here. Again, Congresswoman Stevens opened the door for comment. This is not a closed situation. We have flexibility language in the bill that recognizes that not every healthcare institution is the same. I mean, a psych ward with a person who we know, has a history of physical violence, I mean, that's going to be a different sort of prevention standard than, an ER room or another type of healthcare facility that deals with low-risk patients. And the bill accommodates that. It does not force everybody to have locked wards and security guards every time, a doctor or a nurse goes in to treat a patient. We built in that flexibility in this legislation. So, again, I appreciate the fact that the proponent has, acknowledged that this problem is real and that it's serious. But what I would just say is that, with all of the safeguards, the due process safeguards that we built into this bill, as well as reducing the cost, which I, again, cited the CBO study a minute ago, I think we are in a very comfortable place in terms of a 42-month rulemaking process with an interim standard, which, by the way, is just going to have general sort of global sort of framework. It's not going to have the nitty-gritty details of a workplace standard. And I think that's important for people to recognize. We are not sort of just going to bring down on the system some, highly prescriptive, detailed rule. We're talking about an interim rule only, because we've got to start getting some more protection out there for people. And the horrible cases that we've heard today, but again, that's just, in terms of numbers, it's the everyday incidents of violence that, anybody who talks to folks who work in hospitals can tell you is happening all the time. And that's why we have had such an outpouring from healthcare professional organizations. Mr. Chairman, I would like to ask that the American College of Emergency Physicians, the ER docs, letter in support of the bill be added to the record.
Sorry, Jim.
I wanted to ask that the letter of support for 1195 by the American College of Emergency Room Physicians be admitted to the record.
Without objection.
So I think we ought to listen to the doctors. I think we ought to listen to the caregivers. We ought to listen to the American Nurses Association. We should listen to the EMT guys. And we all know them at the fire stations in our district who are out there probably right now responding to opioid overdose calls, which has unfortunately become one of the real flashpoints for violence against folks. Their endorsement, I think, should speak much more powerfully in terms of how we evaluate and move forward on this legislation. I yield back.
I'm sorry.
Hayes is seeking recognition to speak, sir. Hayes from Connecticut.
Thank you. Thank you. Gentleman's time has expired. Does anyone else seek recognition? Gentlelady from Connecticut, Ms. Hayes.
Thank you, Mr. Chairman. I move to strike the last word.
Young lady's recognized for 5 minutes.
I first want to thank my colleague from Connecticut, Representative Courtney, who has worked tirelessly on this bill, not just for this markup, but for years. As Mr. Courtney has discussed, the issue of workplace violence against healthcare workers is all too common in our home state. In 2010, Danbury Hospital garnered national attention when a former Marine and nurse, Andrew Hull, was shot 3 times by a patient while trying to protect other healthcare workers. This devastating example of workplace violence in the healthcare industry spurred discussion around my state and what we could do to mitigate the disproportionate violence faced by healthcare workers. In 2011, our state of Connecticut passed a law that requires healthcare employers to develop and implement plans, policies, and training programs designed to prevent and respond to workplace violence. Yet, workplace violence against healthcare workers continues and has been exacerbated by the stresses of COVID-19. In a recent survey of 15,000 nurses, 20% reported experiencing workplace violence. A 2018 poll of emergency physicians found that 47% reported physical assault in the workplace. As a former member of SEIU 1199, working in several healthcare facilities, I know that threats continue to be real for so many of my friends who remain healthcare workers. In 2019, Maureen Burns, a registered nurse in Meriden, Connecticut, wrote to the Connecticut Post stating that she had been punched, kicked, spit on, and verbally threatened with violence or sexual harm throughout her 9-year career as a nurse. She noted her friend, also a nurse, had to call the police on a patient who intentionally slammed her wrist on a table because he was angry about his discharge. Currently, Congressman Courtney raises awareness of the story of Helene Andrews, a nurse from my district who was assaulted numerous times throughout her career. These nurses are not outliers. Many other healthcare workers across Connecticut have also recounted painful stories of physical and verbal assault on the job as they try to serve their communities. This is simply unconscionable. Healthcare workers sign up to serve the public, to take care of our neighbors in their darkest days, and to save lives. The high-stake natures of their job does not, however, provide any implicit consent to being assaulted, and they should not be left to fend for themselves and left alone for violence. We have heralded healthcare workers throughout this past year, and now is our opportunity to legislate in a way that helps them and keeps them safe in their jobs. Again, I thank my colleague, Mr. Courtney, for his intellectually superior work on this legislation, and I enthusiastically support its passage. And with that, Mr. Chair, I yield back.
Thank you. Gentlelady yields back. Does anyone else seek recognition? If not, the question is on the amendment offered by the gentleman from Michigan, Mr. Wahlberg. All in favor of the amendment will say aye.
Aye. Aye.
All opposed say no.
No.
No. Noes appear to have it.
Record roll call, Mr. Chairman, please.
The gentleman from Michigan has asked for a roll call vote. Just a minute. Are there other amendments to the bill? If not, having completed consideration of the bills marked up today, we will now begin voting on amendments in the order they were offered, beginning with H.R. 7, the Paycheck Fairness Act. We'll begin with consideration of the amendment offered by the gentlelady from New York, Ms. Stefanik, on which a roll call vote was requested. On the Stefanik amendment, the clerk will call the roll.
Chairman Scott,
No.
Mr. Grijalva, Mr. Courtney,
No.
Mr. Courtney votes no.
Wait,
Hold on.
Could the clerk start all over again?
Yes, I'm sorry.
Brian, thank you.
Chairman Scott.
Chairman Scott votes no.
Chairman Scott votes no.
Okay.
Mr. Grijalva,
No.
Mr. Grijalva votes no. Mr. Courtney,
Courtney votes no.
Mr. Courtney votes no. Mr. Sablon,
Sablan votes no.
Mr. Sablon votes no. Ms. Wilson? Ms. Bonamici?
Bonamici votes no.
Ms. Bonamici votes no. Mr. Takano?
Takano votes no.
Mr. Takano votes no. Ms. Adams?
Adams votes no.
Ms. Adams votes no. Mr. DeSagne? Mr. Norcross? Ms. Jayapal?
Jayapal votes no.
Jayapal votes no. Mr. Morelli?
Morelli votes no.
Mr. Morelli votes no. Ms. Wild?
Wild votes no.
Ms. Wild votes no. Mrs. McBath?
No.
Mrs. McBath votes no. Mrs. Hayes?
Hayes votes no.
Mrs. Hayes votes no. Mr. Levin?
Levin votes no.
Mr. Levin votes no. Ms. Omar? Ms. Stevens?
Stevens is a no.
Ms. Stevens votes no. Ms. Leger Fernandez?
Leger Fernandez votes no.
Leger Fernandez votes no. Mr. Jones?
Jones votes no.
Mr. Jones votes no. Ms. Manning?
Manning votes no.
Ms. Manning votes no. Mr. Mervan?
Mervan votes no.
Mr. Mervan votes no. Mr. Bowman?
Bowman votes no.
Mr. Bowman votes no. Mr. Pocan?
Pocan votes no.
Mr. Pocan votes no. Mr. Castro?
No.
Mr. Castro votes no. Ms. Sherrill?
Cheryl votes no.
Ms. Sherrill votes no. Mr. Yarmouth?
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat? Mr. Mfume? Ranking Member Fox?
Ms. Fox votes yes.
Ms. Fox votes yes. Mr. Wilson?
Yes.
Mr. Wilson votes yes. Mr. Thompson?
Mr. Thompson votes yes.
Mr. Thompson votes yes. Mr. Wahlberg?
Wahlberg, yes.
Mr. Wahlberg votes yes. Mr. Grossman?
Yep.
Mr. Grossman votes yes. Ms. Stefanik?
Stefanik votes yes.
Ms. Stefanik votes yes. Mr. Allen?
Allen votes yes.
Mr. Allen votes yes. Mr. Banks?
Banks votes yes.
Mr. Banks votes yes. Mr. Comer?
Comer votes yes.
Mr. Comer votes yes. Mr. Fulcher?
Fulcher votes no.
Mr. Fulcher votes no. Mr. Keller?
Keller votes yes.
Mr. Keller votes yes. Mr. Murphy?
Dr. Murphy votes no. I'm sorry,
Mr.
Dr. Murphy votes yes.
Mr. Murphy votes yes. Mrs. Miller Meeks?
Dr. Miller Meeks votes yes.
Mrs. Miller Meeks votes yes. Mr. Owens?
Owens, yes.
Mr. Owens votes yes. Mr. Good?
Good votes no.
Mr. Good votes no. Mrs. McLean?
Mrs. McLean votes yes.
Mrs. McLean votes yes. Mrs. Harshbarger?
Harshbarger votes yes.
Mrs. Harshbarger votes yes. Mrs. Miller?
Miller votes no.
Mrs. Miller votes no. Mrs. Sparts?
Sparts, yes.
Mrs. Sparts votes yes. Mr. Fitzgerald?
Fitzgerald votes aye.
Mr. Fitzgerald votes yes. Mr. Cawthorn?
Cawthorn votes aye.
Mr. Cawthorn votes yes. Mrs. Steele?
Steele votes yay.
Mrs. Steele votes yes.
Oops, what happened?
Oh, yeah, I know, but you can hear you.
How is Mr. Desaulniers recorded?
Mr. Desaulniers is not recorded.
Mr. Chairman, I'd like to be recorded as a no vote, please.
How is Ms. Omar recorded?
And how is Ms. Omar recorded?
Ms. Omar is not recorded.
I'd like to be recorded as a no. Thank you.
Ms. Omar votes no.
Anyone else seek to be recorded? Can't find it. Let me see the clerk. Okay. The clerk will report.
Mr. Chairman, on this vote, there are 19 yeas and 28 nays.
19 ayes and 28 nays. The amendment is not adopted. The question now, there are no further amendments. The question now occurs on the amendment in nature of a substitute. All in favor, say aye.
Aye.
Aye. All opposed, say no. The ayes appear to have it. The ayes have it, and the amendment in nature of substitute is agreed to. There being no further members wishing to speak on the bill, I'll now entertain a motion to report the bill and recognize the gentleman from New York, the distinguished vice chair of the committee, Mr. Bowman, for the purposes of a motion.
Mr. Chairman, I move the Committee on Education and Labor report the bill HR 7 to the House of Representatives with an amendment in the nature of a substitute and with the recommendation that the amendment be agreed to and the bill as amended do pass.
The question now occurs on reporting HR 7 as amended to the House with a favorable recommendation. All in favor, say aye.
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 All opposed, say no.
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 The ayes appear to have it.
Mr. Chairman, on that, I ask for recorded vote.
Recorded vote is requested. The clerk will call the roll.
Chairman Scott?
Chairman Scott votes aye.
Mr. Scott votes aye. Mr. Grijalva?
Aye.
Mr. Grijalva votes aye. Mr. Courtney?
Courtney votes aye.
Mr. Courtney votes aye. Mr. Sablon? Ms. Wilson?
Oh, I'm sorry. Sablon votes aye.
Mr. Sablon votes aye. Ms. Wilson?
Apologies.
Ms. Bonamici?
Every time Mark
Bonamici
leaves, we
votes
have to
aye.
do a shot of tequila.
Mr. Takano?
Takano votes aye.
I'm so sorry. Ms. Bonamici is recorded as aye. Mr. Takano is recorded as aye. Ms. Adams?
Adams votes aye.
Ms. Adams votes aye. Mr. Desaulniers?
Aye.
Mr. Desaulniers votes aye. Mr. Norcross? Ms. Jayapal?
Jayapal votes aye.
Ms. Jayapal votes aye. Mr. Morelli?
Morelli votes aye.
Mr. Morelli votes aye. Ms. Wild?
Wild votes aye.
Ms. Wild votes aye. Mrs. McBath?
McBath votes aye.
Mrs. McBath votes aye. Mrs. Hayes?
Mrs. Hayes votes aye.
Mrs. Hayes votes aye. Mr. Levin?
Levin votes aye.
Mr. Levin votes aye. Ms. Omar?
Votes aye.
Ms. Omar votes aye. Ms. Stevens?
Stevens, aye.
Ms. Stevens votes aye. Ms. Leger Fernandez?
Leger Fernandez votes aye.
Ms. Leger Fernandez votes aye. Mr. Jones?
Jones votes aye.
Mr. Jones votes aye. Ms. Manning?
Manning votes aye.
Ms. Manning votes aye. Mr. Mervan?
Mervan votes aye.
Mr. Mervan, I can't see you. Can you repeat with your camera on?
I'm showing it. I see him. What?
Camera is on. Mervan votes aye.
I'm so sorry.
Can you wave your hand, Mr. Mervan?
I'm having technical issues. You're showing as a blank box, sir.
He's
Can I
showing
get
us
back to you?
too.
I don't.
Mr. Mervan, can you wave your hand to show that whether you're on camera or not?
He's not on camera.
Mr. Mervan, I don't see you.
Yes,
I'll come
I
back
will.
to you. I will return to Mr. Mervan. Mr. Bowman?
Mr. Bowman votes aye.
Mr. Bowman votes aye. Mr. Pocan?
Pocan votes aye.
Mr. Pocan votes aye. Mr. Castro?
Aye.
Mr. Castro votes aye. Ms. Cheryl?
Cheryl votes aye.
Ms. Cheryl votes aye. Mr. Yarmouth?
Yarmouth votes aye.
Mr. Yarmouth votes aye. Mr. Espaillat? Mr. Mfume? Ranking Member Fox?
Fox votes no.
Mrs. Fox votes no. Mr. Wilson?
Wilson votes no.
Mr. Wilson votes no. Mr. Thompson?
Mr. Thompson votes no.
Mr. Thompson votes no. Mr. Wahlberg?
Wahlberg votes no.
Mr. Wahlberg votes no. Mr. Grossman?
No, do you hear me? Yep, no.
Mr. Grossman votes no. Ms. Stefanik?
Stefanik votes no.
Ms. Stefanik votes no. Mr. Allen? Mr. Banks?
Banks votes no.
Mr. Banks votes no. Mr. Comer?
Comer votes no.
Mr. Comer votes no. Mr. Fulcher?
Fulcher's no.
Mr. Fulcher votes no. Mr. Keller?
Keller votes no.
Mr. Keller votes no. Mr. Murphy?
Murphy votes no.
Mr. Murphy votes no. Mrs. Miller Meeks?
Miller Meeks no.
Mrs. Miller Meeks votes no. Mr. Owens?
Owens no.
Mr. Owens votes no. Mr. Good?
Good votes no.
Mr. Good votes no. Mrs. McLean?
Mrs. McLean votes no.
Mrs. McLean votes no. Mrs. Harshbarger?
Harshbarger's no.
Mrs. Harshbarger votes no. Mrs. Miller?
Miller votes no.
Mrs. Miller votes no. Mrs. Sparts?
Sparts votes no.
Mrs. Sparts votes no. Mr. Fitzgerald? Mr. Cawthorn?
Cawthorn votes no.
Mr. Cawthorn votes no. Mrs. Steele?
Steele votes no.
Mrs. Steele votes no.
If the clerk could call those that did not respond.
Yes, sir. Ms. Wilson? Mr. Norcross? Mr. Mervan?
Mervan votes aye.
Mr. Mervan votes aye. Mr. Espaillat? Mr. Mfume? Mr. Allen?
No.
Mr. Fitzgerald?
I think Mr. Allen is here.
no. Yeah.
Fitzgerald votes no. Mr. Allen?
Come on, Rick.
Allen votes no.
Okay.
Mr. Allen votes no.
Clerk will report.
Mr. Chairman, on this vote, there were 25 yeas and 22 nays.
25 ayes, 22 nays. The ayes have it. The motion is agreed to. HR 7 is ordered reported to the House of Representatives. Chair notes for the record that a quorum is present and ask unanimous consent that the staff be authorized to make necessary technical and conforming changes to the bill as amended. Pursuant to House Rule 11, Clause 2L, I give notice to all members that they have the requisite number of days to file supplemental, minority, or additional and dissenting views, and without objection, so ordered. And so that bill is reported. We now turn to postpone votes on HR 1065, the Pregnant Workers Fairness Act, and begin with the amendment offered by the gentleman from Idaho, Mr. Fulcher, on which a recorded vote was requested. The clerk will call the roll on the Fulcher amendment.
Chairman Scott.
No. Chairman Scott votes no.
Chairman Scott votes no. Mr. Grijalva.
No.
Mr. Grijalva votes no. Mr. Courtney. Mr. Sablon.
Sablon votes no.
Mr. Sablon votes no. Ms. Wilson. Ms. Bonamici.
Bonamici votes no.
Ms. Bonamici votes no. Mr. Takano. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Mr. DeSaulnier.
DeSaulnier votes no.
Mr. DeSaulnier votes no. Mr. Norcross. Ms. Jayapal.
Jayapal votes no.
Ms. Jayapal votes no. Mr. Morelli.
Morelli votes no.
Mr. Morelli votes no. Ms. Wild.
Wild votes no.
Ms. Wild votes no. Mrs. McBath.
McBath votes no.
Mrs. McBath votes no. Mrs. Hayes.
Hayes votes no.
Mrs. Hayes votes no. Mr. Levin.
Levin votes no.
Mr. Levin votes no. Ms. Omar.
Omar votes no.
Ms. Omar votes no. Ms. Stevens.
No.
Ms. Stevens votes no. Ms. Ledger Fernandez.
You're muted, Ms. Ledger Fernandez.
Ledger Fernandez votes no.
Ledger Fernandez votes
Can I be
no.
recorded, Mr. Takano?
Just a minute, we're gonna come back. We're gonna come back.
Mr. Jones.
Mr. Jones votes no.
Mr. Jones votes no. Ms. Manning.
Manning votes no.
Ms. Manning votes no. Mr. Mervan.
Mervan votes no.
Mr. Mervan votes no. Mr. Bowman.
Mr. Bowman votes no.
Mr. Bowman votes no. Mr. Pocan. Mr. Castro.
No.
Mr. Castro votes no. Ms. Cheryl.
Cheryl votes no.
Ms. Cheryl votes no. Mr. Yarmouth.
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat. Mr. Mfume. Ms. Fox.
Ms. Fox votes aye.
Mrs. Fox votes aye. Mr. Wilson.
As Congressman Pocan goes and votes.
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson.
Mr. Thompson votes aye.
Mr. Thompson votes aye. Mr. Wahlberg.
Wahlberg, aye.
Mr. Wahlberg votes aye. Mr. Grossman.
Sorry,
Oh,
aye.
I'm sorry, Mr. Grossman. Can you
Yeah,
repeat
votes
that?
aye. Votes aye.
Mr. Grossman votes aye. Ms. Stefanik.
Stefanik votes aye.
Ms. Stefanik votes aye. Mr. Allen.
Allen votes aye.
Mr. Allen votes aye. Mr. Banks.
Banks votes yes.
Mr. Banks votes aye. Mr. Comer.
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher.
Fulcher is aye.
Mr. Fulcher votes aye. Mr. Keller.
Keller votes yes.
Mr. Keller votes aye. Mr. Murphy.
Murphy votes yes.
Mr. Murphy votes aye. Mrs. Miller Meeks,
Miller Meeks, yes.
Mrs. Miller Meeks votes aye. Mr. Owens,
Owens, yes.
Mr. Owens votes yes. Mr. Good,
Good votes no.
Mr. Good votes no. Mrs. McLean,
McLean votes aye.
Mrs. McLean votes aye. Mrs. Harshbarger, Mrs. Miller,
Miller votes no.
Mrs. Miller votes no. Mrs. Sparks,
Arts, yes.
Mrs. Sparks votes aye. Mr. Fitzgerald,
Aye.
Mr. I'm sorry, can you repeat?
All aye, Fitzgerald, aye.
Mr. Fitzgerald votes aye. Mr. Cawthorn,
Mr. Cawthorn votes aye.
Mr. Cawthorn votes aye. Mrs. Steele,
Steele votes aye.
Mrs. Steele votes aye.
And if the clerk could call those who did not respond to the first roll call?
Mr. Courtney,
Courtney votes aye. Sorry, no, votes no.
Mr. Courtney votes no. Ms. Wilson, Mr. Takano,
Takano votes no.
Mr. Takano votes no. Mr. Norcross, Mr. Pocan,
And votes no.
Mr. Pocan votes no. Mr. Espaillat, Mr. Mfume, Mrs. Harshbarger,
Hirschberger votes yes.
Mrs. Harshbarger votes yes.
Okay. Clerk will report.
Chairman Scott, on this vote, there were there were 20 ayes and 27 nays.
Thank you. The amendment is not agreed to. The question now occurs on the amendment in the nature of a substitute as amended. Those in favor will vote aye.
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 All opposed, say no.
No.
In the opinion of the chair, the ayes have it. The amendment in nature of a substitute is agreed to. Is agreed to. There being no other members to speak to the bill, I now entertain a motion to report the bill and recognize the gentleman from New York, the distinguished vice chair of the committee, Mr. Bowman, for the purposes of a motion.
Mr. Chairman, I move the Committee on Education and Labor report the bill 1065 to the House of Representatives with an amendment in the nature of a substitute and with the recommendation that the amendment be agreed to and the bill as amended do pass.
Question now occurs on reporting HR 1065 is amended to the House with a favorable recommendation. All those in favor will say aye.
Aye.
Aye. Aye.
All opposed, say no.
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 In the opinion of the chair, gentlelady
Mr.
from North Carolina,
Thank you, Mr. Chairman. On that, I ask for a recorded vote.
recorded vote has been requested. The clerk will call the roll.
Chairman Scott,
Chairman Scott votes aye.
Chairman Scott votes aye. Mr. Grijalva.
Yes.
Mr. Grijalva votes aye. Mr. Courtney.
Courtney votes aye.
Mr. Courtney votes aye. Mr. Sablon.
Sablon votes aye.
Mr. Sablon votes aye. Ms. Wilson. Ms. Bonamici.
Bonamici votes aye.
Ms. Bonamici votes aye. Mr. Takano.
Takano votes aye.
Mr. Takano votes aye. Ms. Adams.
Adams votes aye.
Ms. Adams votes aye. Mr. Desanye.
Aye.
Mr. Desanye votes aye. Mr. Norcross. Ms. Jayapal.
Jayapal votes aye.
Ms. Jayapal votes aye. Mr. Morelli.
Morelli votes aye.
Mr. Morelli votes aye. Ms. Wild.
Wild votes aye.
Ms. Wild votes aye. Mrs. McBath.
Macbeth votes aye.
Mrs. McBath votes aye. Mrs. Hayes.
Hayes votes aye.
Mrs. Hayes votes aye. Mr. Levin.
Levin votes aye.
Mr. Levin votes aye. Ms. Omar.
Omar votes aye.
Ms. Omar votes aye. Ms. Stevens.
Stevens, aye.
Ms. Stevens votes aye. Ms. Lydia Fernandez.
Leger Fernandez votes aye.
Ms. Lydia Fernandez votes aye. Mr. Jones.
Mr. Jones votes aye.
Mr. Jones votes aye. Ms. Manning.
Manning votes aye.
Ms. Manning votes aye. Mr. Mervan.
Mervan votes aye.
Mr. Mervan votes aye. Mr. Bowman.
Bowman votes aye.
Mr. Bowman votes aye. Mr. Pocan.
Pocan votes aye.
Mr. Pocan votes aye. Mr. Castro.
Aye.
Mr. Castro votes aye. Ms. Cheryl.
Cheryl votes aye.
Ms. Cheryl votes aye. Mr. Yarmouth.
Yarmouth votes aye.
Mr. Yarmouth votes aye. Mr. Espaillat.
Oh, this is horrible.
Mr. Mfume. Ranking Member Fox.
Ms. Fox votes no.
Mrs. Fox votes no. Mr. Wilson.
Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson.
Mr. Thompson votes no.
Mr. Thompson votes no. Mr. Wahlberg.
Wahlberg votes no.
Mr. Wahlberg votes no. Mr. Grossman.
No.
Mr. Grossman votes no. Ms. Stefanik.
Stefanik votes aye.
Ms. Stefanik votes aye. Mr. Allen.
Allen votes no.
Mr. Allen votes no. Mr. Banks.
Banks votes no.
Mr. Banks votes no. Mr. Comer.
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher.
Fulcher's no.
Mr. Fulcher votes no. Mr. Keller.
Keller votes no.
Mr. Keller votes no. Mr. Murphy.
Murphy votes no.
Mr. Murphy votes no. Mrs. Miller Meeks.
Miller Meeks, yes.
Mrs. Miller Meeks votes aye. Mr. Owens.
No. Owens
Mr. Owens votes no. Mr. Good.
Good votes no.
Mr. Good votes no. Mrs. McLean.
McLean votes no.
Mrs. McLean votes no. Mrs. Harshbarger.
Harshbarger votes no.
Mrs. Harshbarger votes no. Mrs. Miller. Mrs. Sparks.
Sparks, yes.
Mrs. Sparks votes aye. Mr. Fitzgerald.
Fitzgerald votes no.
Mr. Fitzgerald votes no. Mr. Cawthorn.
Cawthorn votes yes.
Mr. Cawthorn votes
no. Cawthorn votes no.
Mr. Cawthorn votes no. Mrs. Steele.
Steele votes no.
Mrs. Steele votes no.
If the clerk could call those that did not respond to the first roll call.
Ms. Wilson. Mr. Norcross. Mr. Espaillat. Mr. Mfume.
Did I vote right there?
Mrs. Miller.
Miller votes no.
Mrs. Miller votes no.
Clerk will report.
Mr. Chairman, on this vote, there were 30 ayes and 17 nays.
Ayes 30, nays 17. The ayes have it. The motion is agreed to. HR 1065 is ordered reported to the House of Representatives, and the chair notes for the record that a quorum is present. Ask unanimous consent that the staff be authorized to make necessary technical and conforming changes to the bill as amended pursuant to House Rule 11, Clause 2L. I give notice to all members that they have the requisite number of days to file supplemental, minority, additional, or dissenting views. Without objection, so ordered. Now we turn to postponed votes for HR 1195, the Workplace Violence Prevention for Healthcare and Social Service Workers Act, beginning with the amendment offered by the gentleman from Michigan, Mr. Wahlberg, on which a recorded vote was requested. The clerk will call the roll.
Chairman Scott.
Chairman Scott votes no.
Chairman Scott votes no. Mr. Grijalva.
Mute.
Oh. Was
Vote
that the
no.
dog or the vote?
It was both.
Mr. Grijalva votes no. Mr. Courtney.
Courtney votes no.
Mr. Courtney votes no. Mr. Sablon.
Sablan votes no.
Mr. Sablon votes no. Ms. Wilson. Ms. Bonamici.
Bonamici votes no.
Ms. Bonamici votes no. Mr. Takano.
Takano votes no.
Mr. Takano votes no. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Mr. DeSaulnier.
DeSaulnier votes no.
Mr. DeSaulnier votes no. Mr. Norcross. Ms. Jayapal.
Jayapal votes no.
Ms. Jayapal votes no. Mr. Morelli.
Morelli votes no.
Mr. Morelli votes no. I'm sorry, can you repeat that?
Yes, Mr. Morelli votes no.
Yes, I see you now. Thank you, sir. Mr. Morelli votes no. Ms. Wild.
Wild votes no.
Ms. Wild votes no. Mrs. McBath.
McBath votes no.
Mrs. McBath votes no. Mrs. Hayes.
Hayes votes no.
Mrs. Hayes votes no. Mr. Levin. Ms. Omar.
Omar votes no.
Ms. Omar votes no. Ms. Stevens.
No, Stevens is a no.
Ms. Stevens votes no. Ms. Leger Fernandez.
Leger Fernandez is a no.
Ms. Leger Fernandez votes no. Mr. Jones.
Jones is a no.
Mr. Jones votes no. Ms. Manning.
Manning votes no.
Ms. Manning votes no. Mr. Mervan.
Mervan votes no.
Mr. Mervan votes no. Mr. Bowman.
Mr. Bowman votes no.
Mr. Bowman votes no. Mr. Pocan.
Pocan votes no.
Mr. Pocan votes no. Mr. Castro.
No.
Mr. Castro votes no. Ms. Sherrill.
Cheryl votes no.
Ms. Sherrill votes no. Mr. Yarmouth.
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat. Mr. Mfume. Ranking Member Fox.
Fox votes yes.
Mrs. Fox votes aye. Mr. Wilson.
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson.
Mr. Thompson votes aye.
Mr. Thompson votes aye. Mr. Wahlberg.
Wahlberg votes aye.
Mr. Wahlberg votes aye. Mr. Grossman.
Aye.
Mr. Grossman votes aye. Ms. Stefanik?
Stefanik votes aye.
Ms. Stefanik votes aye. Mr. Allen?
Allen votes aye.
Mr. Allen votes aye. Mr. Banks?
Banks votes yes.
Mr. Banks votes aye. Mr. Comer?
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher?
Fulcher's aye.
Mr. Fulcher votes aye. Mr. Keller?
Keller votes yes.
Mr. Keller votes aye. Mr. Murphy?
Murphy votes yes.
Mr. Murphy votes aye. Mrs. Miller Meeks?
Miller Meeks, yes.
Mrs. Miller Meeks votes aye. Mr. Owens?
Owens, yes.
Mr. Owens votes aye. Mr. Good?
Good votes no.
Mr. Good votes no. Mrs. McLean?
McLean votes yes.
Mrs. McLean votes aye. Mrs. Harshbarger?
Hirschberger votes yes.
Mrs. Harshbarger votes aye. Mrs. Miller?
Miller votes no.
Mrs. Miller votes no. Mrs. Sparks?
Barth votes yes.
Mrs. Sparks votes aye. Mr. Fitzgerald?
Fitzgerald votes aye.
Mr. Fitzgerald votes aye. Mr. Cawthorn?
Cawthorn votes aye.
Mr. Cawthorn votes aye. Mrs. Steele?
Steele votes aye.
Steele votes aye.
Oh, is Mr. Levin recorded?
Mr. Levin is not recorded. Mr. Levin?
Mr. Levin votes no.
Mr. Levin votes no.
Here. He wants to what?
Have lunch tomorrow with you.
Am I here tomorrow?
I seem to think you're coming to the office, but there's not a ton on the calendar.
Right.
Is anyone else not recorded? The clerk will report.
Chairman Scott, on this vote, there are 20 ayes and 27 noes.
20 ayes, 27 noes. The amendment is not adopted. The question now occurs on the amendment in nature of a substitute. All those in favor say aye.
Aye.
All opposed say no. The opinion of the chair of the ayes have it. The amendment in nature of a substitute is agreed to. There being no further members wishing to speak on the bill, I now entertain a motion to report the bill and recognize the gentleman from New York, distinguished vice chair of the committee, Mr. Bowman, for the purpose of a motion.
Mr. Chairman, I move the Committee on Education and Labor report the bill HR 1195 to the House of Representatives with an amendment in the nature of a substitute and with the recommendation that the amendment be agreed to and the bill as amended do pass.
The question now occurs on reporting HR 1195 as amended to the House with a favorable recommendation. All those in favor will say aye.
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 All opposed say no.
Aye.
No.
No.
In the opinion of the chair,
Mr. Chairman,
lady from North Carolina,
on that, I request a recorded vote.
recorded vote is requested and the clerk will call the roll.
Chairman Scott?
Chairman Scott votes aye.
Chairman Scott votes aye. Mr. Grijalva?
Aye.
Mr. Grijalva votes aye. Mr. Courtney?
Courtney votes aye.
Mr. Courtney votes aye. Mr. Sablon?
Sablon votes aye.
Mr. Sablon votes aye. Ms. Wilson? Ms. Bonamici?
Bonamici votes aye.
Ms. Bonamici votes aye. Mr. Takano?
Takano votes aye.
Mr. Takano votes aye. Ms. Adams?
Adams votes aye.
Ms. Adams votes aye. Mr. DeSaulnier?
DeSaulnier votes aye.
Mr. DeSaulnier votes aye. Mr. Norcross? Ms. Jayapal?
Jayapal votes aye.
Ms. Jayapal votes aye. Mr. Morelli?
Morelli votes aye.
Mr. Morelli votes aye. Ms. Wild?
Wild votes aye.
Ms. Wild votes aye. Mrs. McBath?
McBath votes aye.
Mrs. McBath votes aye. Mrs. Hayes?
Hayes votes aye.
Mrs. Hayes votes aye. Mr. Levin?
Levin votes aye.
Mr. Levin votes aye. Ms. Omar?
Omar votes aye.
Ms. Omar votes aye. Ms. Stevens?
Stevens, aye.
Ms. Stevens votes aye. Ms. Leger Fernandez?
Leger Fernandez votes aye.
Ms. Leger Fernandez votes aye. Mr. Jones?
Mr. Jones votes aye.
Mr. Jones votes aye. Ms. Manning?
Manning votes aye.
Ms. Manning votes aye. Mr. Mervan?
Mervan votes aye.
Mr. Mervan votes aye. Mr. Bowman?
Mr. Bowman votes aye.
Mr. Bowman votes aye. Mr. Pocan?
Pocan votes aye.
Mr. Pocan votes aye. Mr. Castro?
Okay.
Castro votes.
So I just think.
Mr. Castro, can you repeat that?
Aye.
Mr. Castro votes aye. Ms. Cheryl?
Cheryl votes aye.
Ms. Cheryl votes aye. Mr. Yarmouth?
Congratulations, Joe. Yarmouth votes aye.
Mr. Yarmouth votes aye. Mr. Espaillat? Mr. Mfume? Ranking Member Fox?
Ms. Fox votes no.
Mrs. Fox votes no. Mr. Wilson?
Mr. Wilson votes no.
Mr. Wilson votes no. Mr. Thompson?
Mr. Thompson votes no.
Mr. Thompson votes no. Mr. Wahlberg?
Wahlberg votes no.
Mr. Wahlberg votes no. Mr. Grothman?
No.
Mr. Grothman votes no. Ms. Stefanik?
Stefanik votes aye.
Ms. Stefanik votes aye. Mr. Allen?
Allen votes no.
Mr. Allen votes no. Mr. Banks?
Banks votes no.
Mr. Banks votes no. Mr. Comer? Mr. Comer, can you repeat?
votes no.
Mr. Comer votes no.
votes no.
Confirm, Mr. Comer votes no. Mr. Fulcher?
Fulcher's no.
Mr. Fulcher votes no. Mr. Keller?
Keller votes no.
Mr. Keller votes no. Mr. Murphy?
Murphy votes yes.
Mr. Murphy votes aye. Mrs. Miller Meeks?
Miller Meeks votes no.
Mrs. Miller Meeks votes no. Mr. Owens? Mr. Good?
Good votes no.
Mr. Good votes no. Mrs. McLean?
McLean votes no.
Mrs. McLean votes no. Mrs. Harshbarger?
Harshbarger votes no.
Mrs. Harshbarger votes no. Mrs. Miller?
Miller votes no.
Mrs. Miller votes no. Mrs. Spartz?
Spartz no.
Mrs. Spartz votes no. Mr. Fitzgerald?
Fitzgerald votes no.
Mr. Fitzgerald votes no. Mr. Cawthorn?
Mr. Cawthorn votes no.
Mr. Cawthorn votes no. Mrs. Steele?
Steele votes no.
Mrs. Steele votes no.
I think there may have been some that are present that did not respond to the roll call. So could you run through those that did not respond?
Yes, sir. Ms. Wilson? Mr. Norcross? Mr. Espaillat? Mr. Mfume? Mr. Owens?
Owens no.
Mr. Owens votes no.
The clerk will report.
Mr. Chairman, on this vote, there are 27 ayes and 20 noes.
27 ayes, 20 noes. The ayes have it. The motion is agreed to. HR 1195 is ordered reported to the House of Representatives, and chair notes for the record that a quorum is present. Asking unanimous consent that staff be authorized to make necessary technical and conforming changes to the bill as amended pursuant to House Rule 11, Clause 2L. I give notice that all members have the requisite number of days to file supplemental, minority, additional, or dissenting views. Without objection, so ordered. And without objection, any members who wish to insert materials into the record may do so by submitting them to the committee clerk electronically by the end of the day today. I want to thank all of the members today for their participation. And is there any further business to come before the committee? There being no further business before the committee, without objection, the committee stands adjourned. Thank you very much.
Thank you, Mr. Chairman.